turn to win someone, learn some, but I won't hesitate no more, no more. It cannot wait, I'm sure. Hey, yeah, yeah. Open up your mind, see like me. Open up the blended time, you're free. Look into your heart and you'll find love, 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 love. Listen to the music of the mama, people dance and sing. We're just one big family. It is so God forsake a right to be loved, love, 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 love. So I won't hesitate no more, no more. It cannot wait. I'm sure there's no need.
Lalo na ngayon that we're living in the new normal. Maraming magandang dulot ang internet, pero kaakibat nito ay mga posibleng panganib. Through DTP's e-modules, matututunan natin ang wasto at responsableng paggamit ng internet, cyber safety, online behavior at iba pang mga kaalaman para masiguro that you're safe and protected in the digital world. Bakit kasi naman. There are so many things to love about being connected, but we have to guard ourselves against any form of online abuse. Isa sa pang-aabuso online ay ang cyberbullying. Ang cyberbullying is bullying that takes place over digital devices like cell phones, computers, and tablets. It's using digital technology to harass, threaten, or humiliate you. May iba't ibang klase ng cyberbullying tulad ng mean, vulgar, or threatening messages or images, posted rumors, gossip, or false information na may intensyong magpahiya ng tao, posted sensitive or private information tungkol sa ibang tao, pretending to be someone else with the intention of making the person look bad, intentionally excluding someone from joining an online group. Nakasasama ang cyberbullying sa mental, emotional, at physical health ng mga biktima nito. At dahil online, maaari itong makita ng maraming tao at manatili sa internet indefinitely, causing profound harm to its victims. Laganap ang cyberbullying sa buong mundo, pati na rin sa Pilipinas. In a 2019 study by UNICEF, madalas nagaganap ang cyberbullying sa mga social network sites. Maaari din itong mangyari sa emails at messaging platforms. Ang mga kabataan ang madalas na biktima ng cyber violence, including cyberbullying in the form of verbal abuse over the internet. Kung makakaranas ng cyberbullying, gawin agad ang mga steps na ito. Iset ang inyong social media accounts sa private. Magpagabay sa mga nakatatanda. Huwag pansinin ang mensahe o banta ng cyberbully. I-block at i-report ang cyberbully. I-screenshot lahat ng mensahe o banta ng cyberbully para magamit na pruweba. Kumausap ng nakatatanda na inyong pinagkakatiwalaan at ikwento ang nararanasang cyberbullying. According to the PNP Anti-Cybercrime Group, maaaring mag-file ng complaint sa tanggapan ng NBI Cybercrime Division. Maaaring mapanagot ang mga abusers sa ilalim ng Republic Act No. 10175 o ang Cybercrime Prevention Act of 2012. Malala ang epekto ng cyberbullying sa mga biktima nito. Huwag matakot na ipaalam sa inyong mga magulang o guro kung kayo o may kakilala kayo nakakaranas ng cyberbullying. Sa mga nakatatanda, gabayan ng mga bata. Let them know that you're there for them kung makaranas man sila ng bullying. Know more about cyberbullying. Visit unicef.org/end-violence. Hanggang sa muli, mas marami pa tayong matututunan sa mga susunod na DPP e-modules. Let's create a safer online environment together. Bye! ng ating buhay ang internet. Bukod sa social media, gaming, videos, importante rin ito para sa ating pag-aaral. Lalo na ngayon that we're living in the new normal. Maraming magandang dulot ang internet, pero kaakibat nito ay mga posibleng panganib. Through DTP's e-modules, matututunan natin ang wasto at responsableng paggamit ng internet, cyber safety, online behavior at iba pang mga kaalaman para masiguro that you're safe and protected in the digital world. Oh, ito! Full movie! Ad-free pa! Yes! Dear, hindi maganda yan. Piracy yan. Illegal downloading and streaming. Naku, mapanganib yan. Sayang naman, libre pa naman. Hindi mo na kailangan mag-subscribe. Wait! Hindi ka ba aware sa identity theft? Free nga, pero maaaring may kasamang viruses at malware na pwedeng mag-access ng personal information mo. Gagamitin ito ng mga online thieves to pretend to be you sa internet. Bukod pa dyan, pwedeng ma-access ang camera mo nang hindi mo namamalayan. So no! Ang tagal ko pa namang hinintay to. Marami sa atin ang bumababad sa social media o downloading and streaming sites. Dahil mas madali at mas mabilis nating na-access ang mga content na gusto natin. But not everything on the internet is safe base sa ibinahagi namin at di lahat ay legal. Online piracy is an illegal and criminal act. You do harm to the people working in the industries that you pirate from. Tulad na lang ng movie industry. Oh. Ang mga pelikula ay hindi kumikita kapag marami ang nanonood o nagda-download nito from illegitimate sources. Dahil dito, nawawalan ng budget para gumawa pa ng mga pelikula. Kaya nawawalan din ng trabaho ang mga tao sa industriya. Isipin na lang natin kung ilang tao kasama na ang pamilya nila ang naaapektuhan nito. Dagdag pa riyan ang negative effects ng piracy sa ekonomiya. Ha? Ano namang kinalaman ng piracy sa economy? Dahil ang mga producers ay nagbabayad din ng tax sa gobyerno, lumiliit ito kapag nababawasan ang sales ng kanilang mga pelikula. Masama pala talaga ang effects ng online piracy. Maliban pala sa akin, marami pang buhay ang pwedeng mapahamak. Isang malaking check ka dyan, kaya make sure to always #PlayItRight. Help stop online piracy. Find out more by visiting #PlayItRight website. Hindi porket libre ang mga nakikita natin online, ay tamang i-download o i-stream ang mga ito. Piracy is illegal at may mga batas na nagpipinalize sa mga gumagawa nito. Maraming legitimate at legal sources na pwedeng pagkuhanan ng movies, music, software, at kung ano-ano pa. Ugaliing mag-subscribe sa mga ito para sa safe at secure na content. Learn more about how to #PlayItRight by visiting globe.com.ph/play-it-right. Hanggang sa muli, mas marami pa tayong matututunan sa mga susunod na DTP e-modules. Let's create a safer online environment together. Bye!
Bismillahirrahmanirrahim.
Rise of information, we're here to protect your personal data. The National Privacy Commission is here to serve your data protection. We are one, we support in building a culture of privacy. To monitor, to ensure compliance. to respect and to uphold your right to privacy. Driven by workforce, knowledge based and competitive, committed to excellence and being a leading nation, to empower, to enforce in building a culture of privacy, to monitor, to ensure compliance of the country, to respect and to uphold your right to privacy.
Hindi ako tinanong nung Miss Universe. Pero sa totoo lang, the most significant change I've seen in the world in the past 10 years is the rise of primary mover of policy and economies. Sa mga industriya, tahanan, at mga pamahalaan sa buong mundo, naka-internet at automated na ang mga pang-araw-araw na bagay at gawain, kahit ang paghahanap ng pag-ibig. Ang privacy ngayon, hindi na tungkol sa lugar at kung sino ang iyong kasama. Tungkol ito sa personal information na nais at hindi nais ibahagi sa iba. Kahit ba sa tingin mo, wala ka naman dapat ikahiya o itago. Ang cellphone number mo ba? Kung kani-kanino mo lang ibibigay? I-address, social security number, passport information, pangalan ng mga magulang at paaralan ng mga anak. Ako si Raymond Enriquez Liboro, Chairman ng National Privacy Commission. Trabaho naming siguraduhin ang dapat pribado na nanatiling pribado. Ginagawa namin ito sa pamamagitan ng pagpapaalala sa mga kumpanya at mga ahensya ng pamahalaan na nagpoproseso ng personal na information mo na gawin ang lahat ng nararapat ayon sa batas upang maprotektahan ang mga personal na datos na dapat sa iyo. Pero kalahati lang yan ang laban. Kailangan namin ang tulong mo. Mahalin ang sarili. Pangalagaan ang iyong right to privacy.
In this digital age, personal data protection is everyone's business. While more people are becoming aware of their rights to privacy, special attention must be given to the youth. 81% of the world's youth start online threats. To address this, the Commission launches online environment for the youth. We aim to produce intelligent, observant, and vigilant youth digital citizens. Matalino, a clever digital citizen who exercises data privacy rights. Mapagmatyag, an observant user who discerns what is an acceptable data collection. Mapanuri, a social being who knows what can be shared online. Kabataang digital, matalino, mapagmatyag, at mapanuri. And as we aim to raise awareness among our children, we encourage parents and school authorities to be one with us in this campaign. Join us at the National Privacy Commission in promoting a safe online environment for the youth.
Hay, anong oras na? Di pa rin ako tapos. Break nga muna. Uy, may shotstagram pala si Crush. Pakagawa nga ng account para ma-follow siya. Huh? Ano kaya? Gayahin ko na lang yung password ko sa Facebook. Psst. Tandaan, never use the same password on multiple accounts. Isang paalala mula sa National Privacy Commission.
Online ka na naman? Grabe no, lagi na lang tayong online. We go online to work, to study, to connect with our loved ones, to entertain ourselves. Pero whether we realize it or not, madami talagang threats and dangers on the internet. Siyempre, nandyan ang hacking, ang identity theft, ang online credit card fraud, ang data breach, at kung ano-ano pa. And kung hindi pa kayo nabibiktima nito, well, you are very, very lucky. So how do we stay safe online? In this series of videos, I will be sharing simple tips with you that will help you and your family maintain a safer presence online. Dahil hindi lang natin deserve to feel secure online. It is actually our right. Sa ilalim ng Republic Act 10173 o yung tinatawag na Data Privacy Act, karapatan natin to have our personal information protected and our data privacy respected, especially by organizations or individuals na nagko-collect or nagsusstore or nagko-process ng ating data. So every time we log in sa email or sa social media accounts natin, every time we search online or even watch videos, these rights immediately take effect. So una na dyan, karapatan natin to be informed bago i-collect o i-process yung ating data. So ito yung kapag pumapasok tayo sa ilang websites, di ba dun sa baba, meron parang terms and conditions. Tapos kailangan natin i-check yung box bago tayo makatuloy sa website. And minsan, check lang tayo ng check, guilty din ako dyan, pero mabuti nang binabasa natin ang mga ito. Bukod sa right natin to be informed, meron din tayong iba't iba pang rights sa ilalim nitong Data Privacy Act. Karapatan nating magkaroon ng access to our personal data at malaman kung paano ito nakuha at kung kanino ito i-share. Right din natin to object to having our personal data processed unless part ito ng isang legal obligation. And ultimately, meron tayong right sa data portability. Ibig sabihin, tayo pa rin ang may full control ng ating data in all aspects. Ilan lang yan sa mga data privacy rights natin at kung gusto niyo malaman yung iba pa or if kailangan niyo mag-file ng complaint na sana hindi naman, pwedeng-pwede niyong bisitahin ang National Privacy Commission website. Ito yon. Ngayong meron na tayong idea tungkol sa data privacy rights, pumunta na tayo sa ating first topic para sa video series na ito. Paano nga ba tayo makakasiguro na secure yung mga online accounts natin? Let me share with you 5 tips that will help you maintain a safer presence on the internet. Okay, tip number 1, create strong passwords. So, sino dito ang guilty na 1, 2, 3, 4, 5, 6 or A, B, C, D, E, F ang password? Naku, wag ganon dahil ang tawag doon ay weak password. At naku, madaling-madali ang makuha ng mga hackers. Pati yung mga pangalan ng nanay nyo or pangalan ng street nyo, pangalan ng anak nyo or even birthday ninyo, naku, weak passwords yung mga yan. So, paano nga ba gumawa ng isang strong password? As much as possible, use the maximum number of characters allowed. So, minsan, 8 characters yan, 10 or 12. Tapos, i-mix nyo talaga yung numbers, yung letters, at yung symbols. Pero syempre, dapat matatandaan ninyo yung password ninyo, ha? Pero paano nga ba gumawa ng password na strong at madaling matandaan? Eto, may tip ako para sa inyo. Gumawa ka muna ng isang sentence. Okay, so halimbawa, una akong tumira sa 412 Gomamela Street. 2,000 per month ang renta. Yan ha. Pwede mong i-transform yung sentence na yan into a password by using the first letters and digits of each word. So, ganito ang magiging itsura ng password mo. O, di ba? What's 412 just keep mar. Strong na strong. Super strong password at alam nyo ba kung gaano raw katagal bago mak-crack ng isang computer ang password na yan? 2 trillion years. O, di ba? Hindi na masama. Tip number 2, huwag gumamit ng iisang password para sa iba't ibang accounts. Naku, I know, napaka-tempting na gumamit lang ng isang password for your different accounts para isa lang yung tatandaan natin. Pero, what if, kunyari may hacker na nagkaroon ng access sa iyong username at password sa isang account mo o sa isang website? Naku, may chance din na gagamitin niya yan sa iba't iba pang website or services or social media accounts at kapag nagkataon, naku, lago. Tip number 3, iwasang mag mag-log in sa mga personal accounts mo on free public Wi-Fi. Gets ko talaga nakaka-tempt na gumamit ng libreng public Wi-Fi, pero yung inaakala nating libre, syempre meron yung mga kapalit na risks. Kapag kumonect ka sa free public Wi-Fi sa mga malls or airports or public spaces, na-expose ka sa hackers na naghihintay makuha ng unauthorized access sa personal information mo. Kaya ang advice ko, pagdating sa personal bank accounts, sa sensitive na personal data, pati na rin online shopping, nako, huwag i-access yon kapag nakakabit sa free public Wi-Fi. Hintayin nyo na lang na meron kayong personal Wi-Fi para dito. Nasa huli ang pagsisisi. Tip number 4, mag-ingat sa mga fake emails, sites, or social media accounts. Nako, meron tayong tinatawag na phishing email. At itong phishing, type yan ng online scam kung saan nagpapanggap na legit na kumpanya or organization ng mga cyber criminals gamit ang email or text or ads or iba pang paraan para lang makuha at manakaw nila inyong sensitive information, yung inyong personal information. Madami sa atin may kakilala or nangyari din sa atin na nakareceive ng email o text o tawag mula sa nagpapanggap na authorized representative, di ba? At nagpapa-update ng personal info ninyo. Nako, doble at tripling ingat sa mga ganito kasi kapag nagkataon, nako, ubos ang kaban sa bank account mo. Napakasakit talaga nun. So remember, kahit pa may company logo yan na mukhang legit ang email or maayos naman yung pagkakasulat, nako, if it is asking for your sensitive information or personal info na ang hinihingi sa'yo, always make sure na legit ang source nito at hindi fake ang taong kausap mo. Tip number 5, use two-factor authentication. Itong two-factor authentication, it adds an extra layer of security to make sure na ikaw lang ang makaka-access sa account mo kung sakaling biglang may nangyari at may biglang nakaalam ng password mo. Kumbaga, bago ka makakapag-log on, aside from entering your password, meron ka pang kailangan i-verify. May bibigay sa'yo na code through email or through text para ma-prove mo na ikaw talaga yon. Napaka-importante nito lalo na for accounts na meron talagang sensitive information tulad ng email, ng online bank accounts, pati na rin social media accounts. So, di ba, pili ka. Magsiset up ka ba ng two-factor authentication or maghahabol ka ba ng iyong personal info or baka perang nanakaw sa'yo just because hindi mo na-activate yung two-factor authentication? It's up to you. There you go. 5 simple and practical tips to make sure na secure ang mga online accounts ninyo. Sa susunod na video, mag-share naman ako ng ilang mga tips kung paano mag-navigate safely online. Stay safe from the virus and stay safe online. Bye, guys.
Ang mga serbisyong pang-email at social network accounts ay kadalasan natin ginagamit pag tayo ay nasa labas. Sa iyong telepono ay maaari ma-access ang mga serbisyong ito sa pamamagitan ng mga apps. Dahil dito, isang pindot lamang sa app ang kinakailangan para makalogin. Kaya mahalaga na malaman ang iba't ibang pamamaraan para protektahan ang ating mga devices. Mainam na i-lock ang mga devices kung sakaling maiwan mo ito o di kaya'y may hinala kang mayroong gumagalaw ng iyong telepono. Karamihan sa mga mobile devices ay maaring i-lock gamit ang PIN o pattern. Kung PIN ang iyong nais gamitin, iwasan ang paggamit ng magkakasunod na serye gaya ng 1, 2, 3, 4 o kaya na may personal na impormasyon tulad ng kaarawan o tirahan. Ang prinsipyong ito ay maaari ding gamitin sa paggawa ng pattern. Iwasang gumamit ng pattern na madaling mahulaan tulad ng geometric na hugis. May ibang mga device na nagbibigay ng opsyon na maitago ang iyong pattern na iguguhit. Mainam na maging maingat pagdating sa mga apps, games, videos at mga kalakip na downloads dahil ito ay maaring makasira ng iyong device at maging alerto sa mga mensaheng nagsasaad na ang iyong telepono ay may virus o hinihingi ang iyong password o personal na impormasyon. Maaaring makadownload ka ng nakakasamang mga apps o mabigyan mo ng access sa iyong account ang ibang tao nang hindi mo namamalayan. Para maiwasan ito, palaging tandaan na mag-download mula sa lehitimong app store sa iyong telepono. Mahalaga rin na laging basahin ang mga panunuri at komento mula sa mga nakagamit na ng app at ugaliing alamin ang mga kadalasang problemang pangseguridad nito. Ito ay makakatulong sa iyong panunuri kung ligtas i-download ang nilalaman. May mga pagkakataong makakatanggap ka rin ng mga abiso na mag-download ng system updates sa iyong telepono. Mahalagang panatilihing may pinakabagong bersyon ng operating system ang iyong mga devices dahil makakatulong itong maisaayos ang mga problema sa seguridad. At panghuli, laging tandaan na maging mas maingat sa tuwing gagamit ng network na hindi mo nakikilala o kahina-hinala. Gaya ng paggamit ng libreng wifi sa lokal na cafe dahil madali itong mapasok ng mga kahina-hinalang tao. Iwasang mag-sign in sa iyong mga accounts o mamili online kapag gamit ang pampublikong networks. Ngayong alam mo na ang kahalagahan ng screen locks, maingat na pamamaraan ng pag-download, pag-update ng system, at paggamit ng Wi-Fi networks. Pumili ng safety settings na mainam para sa iyo at limitahan ang mga impormasyon na ibinibigay paggamit ang mobile devices.
Ako ay biktima ng identity theft. May nagnakaw ng data ko, nagpanggap na ako, at nag-loan sa pangalan ko.
Ako ay biktima ng SIM swapping. Gamit yung cellphone number ko, in-access yung mga online accounts ko, pati yung pera ko sa bangko sinimot.
Ako ay biktima ng paninirang puri ng isang lending. Nakuha na pala nila lahat ng phone contacts ko nang walang paalam. Nang minsang na-delay ang bayad ko, pinagkalat nila ito at pinahiya ako. Pati contacts ko hinaras.
Ako po ang inyong Privacy Commissioner Raymond Enriquez Liboro na nagsasabing di mo kailangan manatiling biktima. Fraudsters at violators lang sila. Pero data subject ka. Sa ilalim ng Data Privacy Act of 2012, protektado at may laban ka. Ano mang paglabag sa iyong privacy, ireklamo agad. Tandaan, hindi pwedeng gamitin ang datos mo ng ganun-ganun na lang. Dapat ipinaalam sa iyo. Dapat may consent o permiso mo. Maliban na lamang kung may ibang legal na basehan. Ang consent ay dapat informed, freely given, at specific sa purpose. Hindi rin pwedeng lumagpas sa purpose na ito. At dapat, sakto lang ang dami ng datos na kukolektahin sa iyo. Kakampi mo ang National Privacy Commission dahil naniniwala kami na dapat ang datos ng Pilipino protektado. Hindi ako tinanong nung Miss Universe, pero sa totoo lang, the most significant change I've seen in the world in the past 10 years is the rise of information as the primary mover of policy and economies. Sa mga industriya, tahanan, at mga pamahalaan sa buong mundo, naka-internet at automated na ang mga pang-araw-araw na bagay at gawain, kahit ang paghahanap ng pag-ibig. Ang privacy ngayon, hindi na tungkol sa lugar at kung sino ang iyong kasama. Tungkol ito sa personal information na nais at hindi nais ibahagi sa iba. Kahit ba sa tingin mo, wala ka naman dapat ikahiya o itago. Ang cellphone number mo ba? Kung kani-kanino mo lang ibibigay? I-address, social security number, passport information, pangalan ng mga magulang at paaralan ng mga anak. Ako si Raymond Enriquez Liboro, Chairman ng National Privacy Commission. Trabaho naming siguraduhin ang dapat pribado na nanatiling pribado. Ginagawa namin ito sa pamamagitan ng pagpapaalala sa mga kumpanya at mga ahensya ng pamahalaan na nagpoproseso ng personal na information mo na gawin ang lahat ng nararapat ayon sa batas upang maprotektahan ang mga personal na datos na dapat sa iyo. Pero kalahati lang yan ang laban. Kailangan namin ang tulong mo. Mahalin ang sarili. Pangalagaan ang iyong right to privacy.
Ako ay biktima ng identity theft. May nagnakaw ng data ko, nagpanggap na ako, at nag-loan sa pangalan.
Biktima ng paninirang puri ng isang lending. Nakuha na pala nila lahat ng phone contacts ko nang walang paalam. Nang minsang na-delay ang bayad ko, pinagkalat nila ito at pinahiya ako. Pati contacts ko hinaras.
Ako po ang inyong Privacy Commissioner Raymond Enriquez de Boro na nagsasabing di mo kailangan manatiling biktima. Fraudsters at violators lang sila. Pero data subject ka. Sa ilalim ng Data Privacy Act of 2012, protektado at may laban ka. Ano mang paglabag sa iyong privacy, ireklamo agad. Tandaan, hindi pwedeng gamitin ang datos mo ng ganun-ganun na lang. Dapat ipinaalam sa iyo. Dapat may consent o permiso mo. Maliban na lamang kung may ibang legal na basehan. Ang consent ay dapat informed, freely given, at specific sa purpose. Hindi rin pwedeng lumagpas sa purpose na ito. At dapat, sakto lang ang dami ng datos na kukolektahin sa iyo. Kakampi mo ang National Privacy Commission dahil naniniwala kami na dapat ang datos ng Pilipino protektado.
Malaking bahagi na ng ating buhay ang internet. Bukod sa social media, gaming, videos, importante rin ito para sa ating pag-aaral. Lalo na ngayon that we're living in the new normal. Maraming magandang dulot ang internet, pero kaakibat nito ay mga posibleng panganib. Through DTP's e-modules, matututunan natin ang wasto at responsableng paggamit ng internet, cyber safety, online behavior at iba pang mga kaalaman para masiguro that you're safe and protected in the digital world. Naman. There are so many things to love about being connected, but we have to guard ourselves against any form of online abuse. Isa sa pang-aabuso online ay ang cyberbullying. Ang cyberbullying is bullying that takes place over digital devices like
Good morning and welcome to the DPO 24 Technology Sector Summit. First, we acknowledge the presence of our local government officials, health officials, information security professionals, information management professionals, COVID-19 responders, and all in attendance today. On your screen are the reminders for teleconferencing. This conference will be recorded for reference of discussions and agreements. The following information will be processed during this teleconference: your name, profile photo, text, audio, and video data. Do not share the meeting link to participants who are not registered, as they will not be receiving certificates. Your microphone and camera is disabled by default and will be activated during the open forum. Instructions will be given by the moderator. For identity verification, camera should be turned on. When it is your turn to speak, start by announcing your name, company, designation, and sector. Please hold any questions until the end of the presentations. Do not share links, videos, and any personal data from the teleconference. To reduce one's footprint, do not deviate from the agenda. Only speak when asked and try to solve technical problems on your own first. The event will start in 15 minutes. Please bow your heads for the invocation, to be followed by the singing of the Philippine National Anthem.
مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين آمين.
Heavenly Father, we come into your presence in the name of Jesus. Thank you for your mercies are new every morning. As we take on a fresh beginning in this week filled with your promise, let your presence be upon us. Please bless the works of our hands. Help us to be productive and bear fruits that remains. We recognize that apart from you, we can do nothing. May the Holy Spirit guide and protect us in every step that we need to take, and give us wisdom in every decision we need to make. Provide us with your supernatural joy and strength in the midst of adversity. May we work with an attitude of gratitude, take nothing for granted, and live life to the fullest. Fill our hearts with your love so we can be a blessing to others as you are to us. Teach us your ways, Lord, and help us fix our eyes on you alone. Let your keeping grace sustain us for the rest of the week. This is our prayer. In Jesus' name, amen.
to respect and to uphold your right to privacy. Driven by workforce, knowledge base and competitive, committed to excellence, an innovative nation to empower, to enforce, in building a culture of privacy. To monitor, to ensure compliance of the country, to respect and to uphold your right to privacy.
Good morning again, and welcome to the DPO 24 Data Privacy Summit for the Technology Sector. To formally open the program, may we call on Privacy Commissioner Raymond Enriquez Leboro to deliver the opening remarks.
Good morning to everyone, the NPC, our guests, our panelists, our partners. A pleasant morning to you all. Today's DPO Summit 24 is a very special one. This is the first time that we attempted to group together all app developers and those in the coding and programming industry into a special event where we talk about the privacy and privacy by design of software development. As the developers, you are the first special group of people who know the ins and outs of your software. Hence, it is very important for you to understand that everything you do, from the moment of design, may influence not only the performance of your software, but also those who use it, especially in the context of privacy. In this era, heavily influenced with digital transformation, I would argue that you in the technology sector can make significant impact to the lives of many. Hence, data privacy should be your default posture, even before you begin your programming journey. I remember a quote by Apple CEO Tim Cook years ago, and it goes like this, and I quote, "People have entrusted us with their most personal information. We owe them nothing less than the best protections that we can possibly provide." Privacy is an enabler of trust. Trust promotes the use of your products, services, and technologies. Conversely, the lack of trust will make people suspicious and hesitant to disclose their information, which is critical for data-driven technologies, especially in this pandemic. An example of this are present contact tracing applications. We have observed people using these apps incorrectly, with the majority opting to use aliases and other ways to spoof their identity. Instances of wrong names, numbers, or addresses, contact information render tracing meaningless and results in inaccuracies and wrong data. The lack of trust plays a significant role to this challenge. Even among government, we can see that they would rather develop their own app within their respective jurisdictions. Hence, a lot of contact tracing apps have been developed by different cities, municipalities, institutions, whether in the private or public sector. It is in this light that the NPC last year released its call for contact tracing application developers to act as privacy watchers and create applications and systems where users' data privacy is protected at every level. We also conducted focused meetings with some of the app developers to ensure that they strictly follow NPC's compliance requirements, which includes operationalizing privacy within the system. This year, your NPC, in our efforts to again remind everyone of such fact, reached out to the Department of the Interior and Local Government, or the DILG, and the League of Cities of the Philippines, in order for them to ensure that the respective in-house and partner software developers for their contact tracing apps are apprised of such duty. The duty to safeguard the personal information of the Filipino people at every level of development, while making sure that the application we develop would help mitigate the spread of the virus and ultimately
lead to the flattening of the curve. It is the duty of care, it is the do no harm mindset that we wish to instill on all of you developers of software and systems. It is true that technology helped everyone to cope with the ever-changing environment. It allowed us to connect with each other by chatting with them in messaging apps. It allowed us to purchase products in e-commerce platforms instead of going to the malls physically. And we can now have our food delivered at any time and anywhere instead of dining out. However, the privacy pitfalls are always there. The lack of ethical considerations on how you process data can result in abuses. Perhaps you've heard of the phenomena called online lending apps. These applications offer loans to every Filipino, especially those who are not engaged in formal banking. The loans do not come with a collateral, or so it would seem. However, as users would later learn, the collateral are in fact their personal data and that of their contacts in their phone lists, which all us gain access and permission to. When borrowers are unable to pay, all our companies call them and their contact to harass, coerce, and force the borrowers to fulfill their obligations. These all our companies commit a number of DPA violations and do not afford any respect to the privacy of its users. The victims, whose only obligation is to pay a measly sum of money, were exposed to severe forms of distress, trauma, emotional pain, and other intangible damages. There have been reported suicides because of the social degradation that these victims incur. And all this happened because certain OLA companies and their app developers did not consider privacy at the design of their business model. It is now more than ever the technology sector must do its best to be a source of comfort and convenience instead of the other way around. You must be champions of privacy within your institutions and companies. You have the power to offer applications that respect data privacy above else. Privacy by design, as we so call, should be your mantra. Privacy by design, as the later speakers would explain, ensures that privacy is at every phase of development, and privacy risks are identified and mitigated all throughout. It encompasses various stages of applications development, from modeling to determination of method, defining terms and process, up to analysis of information gathered. Privacy by design begins with the development teams. You, the coders, software developers, IT and technical people should have knowledge on data privacy and best practices for data protection. You should be able to understand the privacy implications behind your codes and systems. You will be the first to sound the alarms when you see that the applications may result in privacy abuses. You're a firm voice within institutions that could convince management to implement pivot strategies when privacy risks outweigh the benefits. You can make the proper suggestions that will uphold data privacy. You, the coders, the programmers, can make that call. And these are the reasons why we are gathered here today. Privacy is not an option, and it shouldn't be the price we have to pay during these times when there's an overwhelming call for technology, both existing and emerging, to be an instrumental component in our pandemic response and in our future. The NPC supports the technology sector in all its efforts to address the needs and demands of the future. We believe in the incredible and exciting benefits that technology may bring mankind. But we should all be wary of privacy risks and do everything we can to avoid them. Privacy begins with you, and at the inception of app development, hence you are the key to the success of our future technologies. So I wish to thank everyone again for gracing this DPO Summit 24. We're so happy that you have accepted and welcomed this event with such tremendous response. We were only expecting around 200 to 250, but as of yesterday, there were around almost 500 who registered for today's event. So mga kaibigan, marami pong salamat sa inyo. Nais kong pasalamatin din yung ating mga partners, Straits Interactive, who will be giving again a very good um, lecture or seminar on the steps on how we can make our practice better and how we can incorporate privacy by design in our practice. So again, good morning and welcome to DPO 24, Data Privacy Summit for the tech sector. And may we have a fruitful day ahead of us. Thank you very much.
Thank you very much, Privacy Commissioner, for those inspiring words. To introduce our speaker, may we call on Mr. Jansen Esguerra, the policy advisor of the technology sector and the key privacy theme leader for bigger tech and social media.
Hi, good morning. Thank you, Sir Jed. So it is my privilege to introduce our our resource person for this morning. So the first resource speaker hails from the province of La Union. He started his legal career in 2012 as a compliance officer. He has accumulated 8 years of extensive experience in tax law, commercial transactions, regulatory compliance, and real property cases. Before entering government service early this year, he was the legal and data protection officer of a startup security tech solutions provider with partnerships with several tech companies in the European Union and Israel. He also served as corporate secretary for an agribusiness company and since 2017 was the director for operations and chief legal counsel for a real estate and leasing corporation. For his advocacy, he served as the executive director of a regional-based foundation for 6 years and was a former instructor for the College of Business Administration and Accountancy of Letran. At present, he serves as the chief of the Compliance and Monitoring Division of the National Privacy Commission. Here is Attorney Rainier Anthony Milanes to give us the overview of the DPA and NPC in building trust in the age of digital transformation. Attorney Milanes, the floor is yours.
Hello, good morning. Thank you very much, Engineer Johnson. I hope everyone can hear me well, and I hope everyone is healthy and safe. So, I'll be the first speaker for today, and my topic is about Data Privacy Act and the National Privacy Commission, building trust in the age of digital transformation. So, I know that everyone has. I feel lucky that I'll be the first one to talk today. So everyone is still awake and attentive for the lecture. So if in any case you can just grab a cup of coffee and have your merienda while I talk about an overview of the Data Privacy Act of 2012 and some important topics included. So this will be a brief overview since everyone who is attending today's summit are members of the technology sector or tech people. So this is not new to you. This Data Privacy Act is not new to you. But I want to as the division chief of the Compliance and Monitoring Division who handles the compliance checks. So we check the compliance of the different PICs and PIPs. So I just want to give you an overview of the important things to consider, important topics in data privacy, on the Data Privacy Act of 2012 and other related issuances. So, yes. Jello, can I share my screen? Thank you.
Yes, Attorney Ram, you can share your screen. Thank you.
Thank you. So this is my topic. So as I've said, Data Privacy Act and the National Privacy Commission, Building Trust in the Age of Digital Transformation. So let me start with an overview of the Data Privacy Act of 2012. So as you know, everyone here is a member of the technology sector. So we are tech people. Also, I consider myself as aside from being a lawyer, I consider myself one of technical, because my job is also technical in nature. So everyone knows that data is the new oil. So data drives our new digital economy. There are infinite possibilities to monetize data. So as you can see, this is a illustration of the different. I've included many of technology PICs in the picture. Most prominent, of course, is Facebook. So this drives our digital economy nowadays. So the Data Privacy Act or Republic Act 10173 or 10173 is an act protecting individual personal information in information and communication systems in the government and the private sector, creating for this purpose a National Privacy Commission and for other purposes. Republic Act number 10173 is otherwise known as the Data Privacy Act of 2012. In the data
Attorney Ram, sorry to interrupt, but yeah, what we can see right now in the screen is the title slide. So it seems to be not moving or something.
Okay, so sorry. Can I ask the technical to just flash? I apologies. Okay, can you see it?
Yes, Attorney Ram, we can see your slide at slide number 3.
Okay, thank you. So as I was saying, next slide, please. So next slide. Yeah. Within the Data Privacy Act, it says that it is the policy of the state to protect the fundamental human right of privacy of communication while ensuring free flow of information to promote innovation and growth. Now, in the Constitution, there is the right to privacy and the protection of the right to communication and correspondence. These are what we can say is these are broader, broader. They have a broad scope. Sorry, broad scope of the right to privacy. But in this the Data Privacy Act, we focus on data privacy, which is the data of the citizens of our country. So next slide, please. So as I was saying, right to privacy in its broad sense is the right to be let alone. Also, it is the individual's ability to control the flow of information concerning or describing him, which however must be overbalanced by legitimate public concerns. In the same vein, free flow of information includes freedom of the press, research for public purposes, and the right to information or freedom of information. Well, in 2016, there is an executive order signed, the freedom of information, allowing access to freedom of information. We can differentiate this from the Data Privacy Act, such as that the freedom of information is the freedom of the information held by the government. So that is supposed to be available to the public for transparency purposes. While the Data Privacy Act mainly regulates the our PICs and PIPs and give rights to our data subject with regard to their personal data. Okay. So that's the two big differences of a right to freedom of information and right to data privacy. Next slide, please. So right to informational privacy is the right to privacy of an individual to control the collection of, access to, and use of personal information about him or her that are under the control or custody of the government and the private sector. So next slide, please. So when we talk about data, there are the Data Privacy Act regulates processing of personal data. So processing refers to any operation or any set of operations performed upon personal information, including but not limited to the following. So I just enumerated a few, which is collection, recording, organization, storage, updating or modification, retrieval, use, consolidation, blocking, erasure, destruction, and consultation. Basically, processing is in its entirety is the moment you collect personal data up to the moment you destroy personal data, or since the lawful basis or legitimate purpose of the collection and storage is already done, it is your duty to for the destruction or erasure of for the destruction of these personal data that you have in its possession, because your legitimate purpose has already ceased to exist. So I'll delve on that later on in the presentation. These are just preliminaries so that we can understand the different we can define the different things that are included in the Data Privacy Act. Sorry. Next slide, please. So now we have, these are the three kinds of information that is covered by the Data Privacy Act. The first is personal information, or what we normally call PI in our daily activities in the Compliance and Monitoring Division. So what is personal information? Personal information is any information, whether recorded in a material form or not, from which the identity of an individual is apparent or can be reasonably and directly ascertained by the entity holding the information, or when put together with other information, would directly and certainly identify the individual. So as the definition goes, it's not really personal information. It's just not just your name. You can also use other data or other identifiers that could relate to the person. So even though the person does not give his full name, but if all the information that is gathered we can deduce that this person is indeed the person who is we are identifying, then it certainly identifies an individual. So it's part of personal information. Now, sensitive personal information is information in the enumeration in the law, Data Privacy Act. It's information of race, ethnic origin, marital status, age, color, and religious, philosophical, or political affiliations. We can also include health, education, genetic, or sexual life of a person, or to any proceeding for any offense committed or alleged to have been committed by such person, the disposal of such proceedings, or the sentence of any court in such proceedings. Sensitive personal information also is issued by government agencies peculiar to and any individual. We can there are social security numbers, your health records, your licenses like your driver's license, PRC license, or your license to operate. Its denials, suspension, revocation, and also the BIR with regards to your TIN numbers and your income tax returns. Sensitive personal information also includes those specifically established by law to be kept classified, which are also what we call privileged information, or which any and all forms of data in which, under the rules of court or other pertinent laws, constitute privileged communication. So examples of this is husband and wife, the communication between husband and wife, the lawyer-client relationship. So there's communication between lawyer and client, communication between doctor and patient, priest penitent, and executive privilege. These are what comprises the enumeration for the classification of privileged information. Next slide, please. So in the Data Privacy Act, we have personal information processors, or what we call PIPs. We also have personal information controllers, or what we call PICs. And of course, the data subject. So what is a personal information controller? So the personal information controller controls the processing of personal data or instructs other to process personal data on its behalf. So the personal information controller controls the processing. So from the moment of collection until the moment of this destruction, the personal information controller has control over personal information, over personal data. Okay. So in the definition, it also says that it instructs other persons to personally process data. So to process personal data. So who is this other persons or other organizations? These are the personal information processors. So in the definition, a personal information processor, or PIP, is any natural or juridical person to whom a PIC may outsource or instruct the processing of personal data. So this outsourcing or this instruction of the processing of personal data comes from the personal information controller. So it may be via contract or service contract between the personal information controller and the personal information processor, so that the personal information processor does the processing of personal data on behalf of the personal information controller. So the personal information controller has control. The personal information processor only processes personal data upon the instruction of the personal information controller, and not the other way around. So the responsibility for data privacy lies to both the personal information processor and the personal information controller. Personal information processor is should be excuse me, should know data privacy well before processing information, and of course the personal information controller should process personal information with data privacy in mind. So on the other side of the slide, we call there's a data subject. So it is an individual whose personal, sensitive personal, or privileged information is processed. Now, the data subject, members of the personal information controllers and personal information processors, their employees, are also data subjects. Okay, so everyone are data subjects depending on what personal and sensitive personal data they share, and the personal information controller collects, or the personal information processor collects. So I hope that's very, very clear. So I'll move on to the next slide. Thank you. So this is the most important slide that I want to emphasize, because this is going to be until the very end of this presentation, this will always come to mind, no? The general data privacy principles. This is a very important. I want everyone here to take this to heart, that this is in all our doings when we think about data privacy, and when we think about how to incorporate data privacy in our operations. This is your base, or this is your foundation. So I would like to again emphasize these 3 general data privacy principles are the most important in this lecture. So please, you have to know and understand these 3 concepts. So the first one, transparency. Okay, so the data subject must be aware of the nature, purpose, extent of processing of his personal data. So we should be transparent. And how do we demonstrate our transparency? So when we code, or when we I'm sure most of us here are software developers, no? So we really have to do to be transparent in what we are developing. So the most effective way to be transparent is to have a data privacy notice, or a privacy notice. So I would like to emphasize the difference of
disconnect charger. Battery 100%. Disconnect charger.
Apologies
Make
for
sure
that.
it's above 85%.
So I would like to differentiate the concept of a privacy statement, a privacy notice, and a privacy policy. Privacy statement is a general statement that the PIC, no, or the company is stating or giving to or delivering to its customers or consumers that they are adhering to the Data Privacy Act, and they do data privacy and security measures on their processing of personal data. A privacy policy is the one internal facing. This is what we call what we use internally in our operations. So this privacy policy is facing your employees, or the members of the company, or the members of your organization or agency. These are the policies that we adhere to, and we would like to also walk the talk, no? So we also practice the data privacy within our organization. While on the other hand, the privacy notice is the external facing notice. So this targets your the data subjects. So this targets your customers, your clients. This is the one that they read to be appraised of the different rights, to know who to call in case there is a complaint, or in case they want to raise to exercise their rights. This also includes your legitimate purpose of your collection and processing of personal data. And this is the privacy notice is one important notice or tool in the applications or web pages that we look into when we check the different PICs and PIPs for their compliance. So this is one of the first that we conduct a compliance check on. If you're transparent in what in your processing activities, then it should be all your processing activities and all the information should be included in your privacy notice. Since this privacy notice is, sabi ko nga, it is external facing. So ito yung nakikita ng ating mga consumers and customers. So sa amin, in our regulation, when we check your compliance with the DPA and other issuances of the National Privacy Commission, we look into your privacy notices. We look in if it's complete, if it's really giving our data subjects information needed for them to exercise their rights or the rights of the data subject, which I will tackle later on in the presentation. Okay, that's basically that's the concept of transparency. Now I go to legitimate purpose. Legitimate purpose by definition is the processing of information shall be compatible with the declared and specified purpose, which must not be contrary to law, morals, or public policy. Now, in sections 12 of the DPA, you can find there the criteria for lawful processing of personal information. While in section 13, you can see criteria for lawful processing of sensitive personal information. What is common in both, and what's common in both, and it's really what's applicable to this sector is consent. No, so this is important since when we develop applications, when we develop our web pages, web tools, when we make our privacy notices and privacy policy, we need to have a legitimate purpose. So, number one in the enumeration of section 12 and 13 of the Data Privacy Act, which is the criteria for lawful processing of either personal information and sensitive personal information, the number one in the enumeration is consent. So, so what is consent? The data subject must agree to the collection and processing of personal information. They must give their consent. So what are the characteristics of consent? It must be freely given. It must be specific, and there should be an informed indication of will. So this is evidenced by either electronic or recorded means like signature or the action of clicking an icon or an opt-in box. Also sending a confirmation letter or confirmation email, and also giving oral confirmation. It's also considered consent. Consent means giving the data subject a genuine choice and control over how a PIC or PIP uses their personal data. Okay? So data subjects must be able to refuse consent and must be able to withdraw consent easily at any time. So when we say consent, the data subject must be able to refuse. So the data subject must be able to not give his consent or her consent. Or if he has given his or her consent, pag naisip niya, sabihin niya, ay, ayoko na pala. So dapat binibigyan din natin siya ng chance na bawiin yung binigay niyang consent. That is the best practice in privacy. No? So also, one thing to note is consent should be unbundled, no? From other terms and condition whenever possible. Unbundled means hindi dapat siya, yung consent, hindi siya kasama. For example, sa terms and conditions, when we agree to the terms and conditions, we just agree to the terms and conditions. We do not give consent on other factors. So for example, when you agree to the terms and conditions, you also agree for when you make a statement like, when you agree to the terms and conditions, you also agree for us to send you daily updates. So what I'm saying is consent should be unbundled. So if we agree to the terms and condition, we might not agree that they will send us, no, for a data subject, he might agree to the terms and condition, but he might not agree to receiving via email or via letter, receiving what was my example? Sorry, receiving daily updates. No, so it should be unbundled. It should be separate. No? So when they tick a box, for example, it's a tick box. So when they tick a box for agree to the terms and condition, another tick box should be for the receiving, no? Or they agree to receive daily updates from this PIC. So those should be unbundled, and those should be two separate, because consent must be at whenever possible must be unbundled, and there should be options. No? We give options to our data subjects. Also, consent is a clear affirmative action, means someone must take deliberate action to opt in. So again, hindi siya naka-check na agad. So if ever babasahin nila yung privacy notice mo and they have to agree with your terms and conditions or your privacy notice, or a privacy pop-up or a notification, hindi dapat naka-check na yon to okay. Dapat by default it's not unticked, or hindi pa siya na-check if it's a checkbox, or if it's a tab, naka-off yung tab. So that's one best practice for data privacy. I would like to just to reiterate consent for legitimate purpose, because this applies to this sector. The legitimate purpose, your criteria for processing personal data is consent. Okay. So the third one, the third general data privacy principle is proportionality, or the processing of information shall be adequate, relevant, suitable, necessary, and not excessive. So emphasis on not excessive in relation to a declared and specified purpose. In our experience in the Compliance and Monitoring Division, when we check for the compliance of PICs, this is one big issue that we normally in a day-to-day basis we come across an issue of proportionality, because there has the collection, the practice here in the Philippines is to just collect and collect, no? So that's a dangerous thing. What we want, what the Data Privacy Act, the general principles of the Data Privacy Act, especially proportionality, wants us to collect only what is necessary and not be excessive in our collection. So, the mindset kasi siguro ng mga PICs nowadays is, let's collect it, and then, let's collect everything, and then baka may paggamitan tayo later on. So, but that is really dangerous. So, pag wala kang paggagamitan, hindi siya kasama sa specified purpose mo, huwag mo siyang i-collect. Kung hindi naman kailangan yon para mag-run yung system mo, or hindi naman it's not needed to have this to operate your business. Hindi mo kailangan yung sex nung hindi mo kailangan yung gender, hindi mo kailangan yung political affiliation niya. Diba? Huwag nating i-collect yung hindi natin kailangan. Let's limit ourselves to what is needed to run our business. Let's keep ourselves to what is needed to operate the system, or to give our service, no, to our clients or customers. Proportionality. This is one major concern in mostly all of the compliance checks that we have done. since I came into the Compliance and Monitoring Division, lagi kong nakikita yung issue ng proportionality laging nandun. So yung iniisip natin na bakit ko sinasabing dangerous? Why do I say that this is really dangerous? Yes, because in the event there is a personal data breach. So kung sana hindi mo kinolect lahat, konti lang yung personal data na mako-compromise. But in a sense, pag kinolekta mo lahat, kahit hindi mo kailangan, tapos nagkaroon ng data breach, mananagot ka dun sa kinolekta mo na hindi mo kailangan. Diba? So, malalaman yan na you collected information that is not needed. After thorough evaluation, we see after a personal data breach and a thorough evaluation, we see that you collected information that is not needed to operate your business or run your system. That's one big, yun yung one big infraction or one big liability na magiging dahilan kung bakit you'll be ma-fine ka or makukulong ka dahil may unauthorized processing of personal data. Makukulong yung DPO or makukulong yung head of depende if the data breach has evolved into a case and then a case is filed, and this all comes into consideration. So the best thing really is to practice proportionality at the onset. Processing of personal information shall be adequate, relevant, suitable, necessary, and not excessive in relation to the declared and specified purpose. Importante talaga yung proportionality. I would like to emphasize it once again. Proportionality of your collection. Collect only what is necessary. Collect only what is adequate, relevant, suitable, necessary, and do not over-collect. Okay. So again, this is our foundation. This is the baseline. This is our foundation when we practice data privacy in our organization. We should be transparent. We should only process within a legitimate purpose, and the collection or process the collection of personal data should be proportional to what is just needed. Okay. Emphasis again, transparency, legitimate purpose, and proportionality. Thank you. Next slide, please. So this slide gives you the obligations of a personal information controller. As I've said and as I've emphasized all together in the last slide. So I'll just read through it. The PIC should collect personal information only for a specified and legitimate purposes. So that's a legitimate purpose. The PIC should process personal information fairly and lawfully. So yeah, legitimate purpose. The PIC should process accurate, relevant, and up-to-date personal information. The PIC should collect and process personal information adequately and not excessively. So this is proportionality. The PIC should retain personal information only for as long as necessary. The PIC must implement reasonable organizational, physical, technical, security measures to protect personal data. These are the main obligations of a personal information controller. But there are a lot when we practice personal data and data security. There are a lot of other obligations. But this is in relation to the Data Privacy Act. This is what the obligations of the personal information controller. And also, I would like to emphasize, this is a continuing obligation. The compliance to the Data Privacy Act and compliance to these obligations is a continuing one. So you may be, for us in the Compliance and Monitoring Division, you may be assessed to be compliant to the Data Privacy Act, but due to a change in a circular or there is a change in the technology, where there's a change in global standards for data privacy, then you should be up to date. And so pwedeng compliant ka today, but tomorrow dahil may bagong batas or may bagong internationally accepted na principle or internationally accepted na security involving data privacy and security, bukas hindi ka na compliant. So it's a continuing obligation to comply with the Data Privacy Act. I just want to emphasize that. Next slide, please. Yes. So I was saying, since all of us who are members, who are 475 of us here, although we have different companies, we have different agencies, we are all data subjects. So you need to know what are your rights as a data subject. Well, this is the enumeration of your rights: the right to be informed. So you have the right to be informed. So every application in web should have a privacy notice, since all the data subjects have the right to be informed. So the way to inform your data subjects is through your privacy notice. So the right to be informed, basically the right to be informed about the processing of their personal data. The right to access, the right to object, the right to erasure or blocking, the right to damages, the right to file a complaint, the right to rectify, and the right to data portability. So lahat tayo, kanina 475 yung bilang. So around 483 na ngayon. So nadadagdagan tayo. So yan, lahat tayo, we are data subjects and we have these rights as data subjects. Next slide, please. Next slide, Jello.
Attorney Ram, we are in the Data Privacy Act as compared to the GDPR.
Sorry, na-late lang yung ano.
Previous slide po tayo.
Previous slide, please. Sorry, previous slide. Yeah. Okay. So, apologies for the technical issue. So, I want to touch on, although there will be a discussion, a thorough discussion on this for the later speakers. I want to touch on privacy by design, because this is really important, an important topic in relation to the Data Privacy Act and the overview. No? So I would like to first touch on privacy by design. So the term privacy by design means nothing more than data protection through technology design. Behind this is the thought that data protection in data processing procedures is best adhered to when it is already integrated in the technology when created. So many of us might have been introduced to privacy by design when the European Union codified it in Article 25 of the GDPR. What is GDPR? General Data Protection Regulation. Okay. It prescribes the implementation of technical and organizational measures designed with the data protection principles in mind. So, na-codified. It's codified. Naging part siya ng batas through Article 25 of the GDPR. This GDPR, ito yung Data Privacy Act ng EU or the European Union. Okay? However, privacy by design is a concept coined long ago by Dr. Anne Cavoukian, the former Information Privacy Commissioner of Ontario in Canada. he says, as she says, this is to address the ever-growing and systemic effects of information and communications technology on our privacy. As correctly pointed out by her, privacy by design advances the view that the future of privacy cannot be assured solely by compliance with the regulatory framework. Rather, privacy assurance must ideally become an organizational's default mode of operation. So privacy by design means it's your default mode of operating your business. So I'd like to share with you one thing that I experienced before I joined the government. So before I started my stint in the government early this year, in 2018, when the GDPR was implemented in Europe, I once was a data protection officer and consultant for several corporations with ties to the EU here in the Philippines, the local corporations here in the Philippines. And I would always emphasize that privacy is good for business. And nakatingin lang sila sa akin, parang laki ng question mark sa noon nila. Sabi, privacy, it's good for business. Sabi nila, gastos. Which is, yeah. Sabi ko, when I go on to elaborate why privacy is indeed a business issue, rather than some technical or other issue, it's a business issue. Kasi syempre sabihin nila, there is cost. Okay? That's true. There is cost. When you do privacy by design, there's money involved. There's cost. Diba? You can incur a loss because syempre you will ito dagdag na security measure. No, but diba? Ang ano niyan, it's a fraction of the cost when you are involved in a data breach. So when you're involved in a data breach and you don't have a sense of privacy in your system or sense of privacy in your organization and you're involved in a data breach, that is very catastrophic. But for data privacy lawyers and lawyers altogether, it's business. So because dyan nalalabas yung court cases, but there are not only in your locality, but you may be involved in court cases outside the Philippines because of a personal data breach. Kasi baka hindi lang personal data ng Filipinos ang na pumapasok sa system mo. And once you are part of a class action lawsuit or you're part of a case, it's gonna be the cost to compromise every individual affected is gonna be massive. So again, aside from in the Philippines, if sa atin when we assess when we evaluate your data breach notification and we see that you don't have the proper security measures to prevent the breach, diba? You may be liable for unauthorized processing of personal data, or you may be liable because you added to the risk na breach yung organization. So yung cost, di ba? I emphasize the cost of doing privacy by design in including it in your operations, in your business. The cost is minimal compared to the cost of the loss. When you the cost or the loss that you will have to endure when you are subjected to when you have a security incident or a personal data breach. Yeah. So I did say GDPR a while ago, since in the GDPR was implemented in around May 2018. The Data Privacy Act was implemented around September in 2016. So nauna yung DPA, but the DPA does not have a provision for privacy by design. but you can see when we use the general principles, it's typically privacy by design is the general principles, which is yung tatlo kanina, which is legitimate purpose, proportionality, and transparency. We will come to realize it once I do the next slides. No? So I did mention GDPR, which is it's the General Data Protection Regulation. So privacy by design means that privacy is already integrated into the technology, your IT system, services, the products to ensure data protection. Basically, the entire engineering process is conducted with privacy in mind. The GDPR incorporated privacy by design by assigning the controller the responsibility to implement appropriate technical and organizational measures into the design and operation of the systems and infrastructure. Those measures are designed to effectively implement data protection principles and integrate the necessary safeguards into the processing to meet the regulatory requirements and protect the rights of the data subject. So as I was saying, the Data Privacy Act went into effect around September 2016. However, many organizations now face the new challenge from the EU General Protection Regulation, which is the GDPR, which came into effect May of 2018. Although the GDPR is an EU law, it applies to any organization in the world that collects EU residents' personal data. So this will be particularly tough in the Philippines as the data protection laws are intricately detailed as the GDPR. But on the plus side, if you're compliant with the DPA, you're already 90% compliant of the GDPR. So if you would like to expand your business, you go global and you expand your business and include Europe, since this is my example, the GDPR. So if you're compliant with the Data Privacy Act, konti na lang ang kailangan mo i-comply. Compliant ka na rin with the GDPR. It's almost it's almost the same, 90% compliant. If you're compliant with the DPA, you're almost 90% compliant with the GDPR. So as I was saying, I want to as an illustration of what I'm saying. Next slide, please. Some comparisons of the Data Privacy Act as compared to the GDPR. So as state personal data information, mas yung ano natin ng data privacy, yung concept natin of data privacy was more encapsulated, no? Mas detailed yung pagkaka-describe rather than yung sinasabi sa GDPR, which personal data, personal information versus personal data. It's the same, but yung pagkaka-describe lang nila is personal data means any information related to unidentified or identifiable natural person. Whereas yung sa atin, mas identifiable kasi we included from which the identity of individual is apparent or can be reasonably then directly ascertained by the entity holding information on where put together with the other information will directly and certainly identify the individual. So yun yung sinasabi ko, kahit hindi natin alam yung pangalan, but we have lots of data na possible identifiers kung sino siya, malalaman natin. For example, you add the address plus the age, plus the birthday, plus the email address, then malalaman natin who is that person kahit hindi natin alam kung ano yung pangalan niya. Next slide, please. So again, purpose limitation, it's just the same. The collection should be for a legitimate purpose. This is what I was one of the principles, general principles of in the Data Privacy Act. Purpose limitation or in other words, legitimate purpose. So basically, I just want to show you that it's practically the same. It just worded differently, but it's practically the same. Purpose limitation. Next slide, please. Next slide. Thank you. Data minimization or proportionality. So it's also in our DPA. So DPA and GDPR, sabi ko nga, if you're compliant with the DPA, you will also be compliant with the GDPR if you want to expand your business outside the Philippines. I just used the example because the GDPR used the privacy by design. They codified, they incorporated privacy by design. The EU incorporated it to the GDPR. So I just want this comparison. So hindi talaga nagkakalayo, parehong-pareho lang. Next slide, please. Sorry, Jello, next slide. Yeah. So what is privacy by design? I'll go through this fast lang. I think this will be discussed later on, so I leave it to the experts to discuss on this. But I just want you to have an idea what is privacy by design. It's basically 7 foundational principles coined by Dr. Ann Cavoukian, way before the GDPR. So inadapt lang siya ng GDPR, where yung first is proactive, not reactive, preventive, not remedial. Sabi ko nga, sa mga businesses before na I was a consultant, sabi ko, yung proactive loss is better than reactive loss. Or the proactive cost is better than the cost of a reactive measure. Proactive means privacy by design. Dapat before we do processing, we consider privacy by design or privacy in mind. Hindi yung saka na lang tayo magko-comply with the Data Privacy Act or magko-comply with data privacy pag nagkaroon na ng personal data breach. So reactive yon. If we do the reactive, mas malaki yung cost. I want to emphasize that. Proactive, not reactive, preventive, not remedial. Okay? Next principle is privacy as a default setting. It just means that no action is required on the individual's part to protect their privacy. So this is also known as privacy by default. When privacy is built into the system, it protects personal data by default. This especially includes purpose specification, collection limitation, data retention periods, data minimization, data disclosure limitations, among others. So privacy by default is privacy yung ating 3 general principles, which is if you do privacy as the default setting, you should be transparent, you should process data with the process data with a legitimate purpose, and you should collect proportional. So nandyan ulit siya. Privacy by design, number 2 principle. Lalabas ulit yung ating general principles in the DPA. Okay, next. Number 3 principle is privacy embedded into the design. Privacy is embedded into the design. It practically means the privacy is an essential component of the functionality or the technology that is being delivered. So kasama talaga siya. So we need to adopt a systematic principle approach. We need to carry out our privacy impact assessment, and we need to minimize privacy impacts. Okay? Number 4, positive sum and not zero sum. Basically, privacy and business. Parang privacy plus business. Positive sum, not zero sum. Hindi lang business is business. We need to include privacy in our business. When we do marketing, privacy plus marketing. Hindi hindi marketing only. We should include privacy always. So privacy plus marketing, privacy plus privacy plus technology, privacy plus innovation. Hindi technology only, hindi technology innovation, positive sum. Okay? We embed privacy into the design. We reject a zero sum manner, and we enable multifunctionality. That is the number 4 foundational principle. End-to-end security, full data cycle protection. So privacy by design ensures a secure personal data lifecycle. privacy needs to be maintained through each phase of the data processing. And security standards must assure confidentiality, integrity, and availability of personal data throughout its life cycle, including the data deletion, encryption, access control, and logging methods. So number 6, visibility and transparency. Sabi ko nga, data privacy principle pa rin, principle of transparency. Diba? The privacy by design assures that business practice or technology involved in operating according to the set out goals and objectives is subject to independent verification, and technology components should be included in the fair information practices, which includes accountability, openness, transparency, and compliance. So basically, general principles in the DPA. Okay? And then number 7, which is the last foundational principle, is respect users' privacy and keep it user-centric. So user-centric means you give your data subject an active role in the management of their own personal data. When you do privacy by design, you embed a system that you give an active role in the management of personal data to the data subject. Personal information yon. He or she has the right to have active control, to manage his or her personal data. So you should respect user privacy. You should respect the data subject rights. I enumerated it a while ago. There are 8 data subject rights. You should respect it, and you keep your systems or operations on your business, your apps, your websites, you keep it user-centric. Again, active role in the management of their own personal data. Yeah, the data subject should have an active role in the management of their personal data. Okay, so privacy by design. Why is this important? Because it is important for you to earn your consumers or your customers' trust. No, there's a saying, sabi nga nila, trust takes years to build, seconds to destroy, and forever to repair. So, totoo po ang forever. There is forever. Forever. It would take you forever to repair if there is loss of trust in your customers, if there is loss of trust in your consumers, because there was an incident, there was a security incident, there was a personal data breach. And when you're involved in that and you did not do privacy by design and you did not comply with the Data Privacy Act, it's gonna be a great loss to your, not only monetarily, but also to the reputation of your organization, agency, and also there would be a massive loss of trust by your customers and your consumers. So next slide, please. Thank you. So basically, I just enumerated some that you can practice. No, privacy by design implementation for designers. So before even thinking about coding, you should be doing privacy by design. So privacy in mind before coding. So privacy first before coding. Privacy and innovation. Privacy and business. It comes together, no? So one of the best, I enumerated 4 best practices for you to digest, no? One includes you introduce a clear privacy and data sharing notices. So this also involves a data privacy principle of the DPA, which is what? Transparency. So nandiyan na naman. Transparency, lalabas na naman. Your notices should cover all the ways that you could potentially use the data. You can, example, if you want to provide better user experience, you need to be transparent, and you say it to your customers, you say it to your target audience. If you're displaying target ads, sharing information with third parties, etc., you all need to be transparent with this. If you might use data for something other than the purpose for which you are collecting it, you need to include specific consent. So what? Consent equals legitimate purpose. Again, general data privacy principle. You need to briefly describe what happens to the data once the user has submitted. It is stored in the database sent to a third party. You need to tell them how long it is stored for. Also, when you use large volumes of data through a site and its data is automatically collected in a form of cookies, you need to actively inform your sites or users if you use cookies. No? You give them a clear option to accept or refuse the use of cookies. Also, you provide a method for the users to opt out of the use of cookies. Number 2 is the display in just-in-time notices. So just-in-time notices are high-level layer of information that work by displaying a short message as soon as the user is about to enter their information in the form. So it gives you an opportunity to tell your users about the data you're collecting and how you'll manage the data at the point of collection. So parang if the clicks on the form, din may lalabas na pop-up na nandun na lalabas. You're transparent na sasabihin mo kung ano yung paggagamitan mo ng personal data nila. This is one good best practice, no, for developers. Number 3, to be implemented, don't pre-tick checkboxes. So dapat hollow boxes lang. Pag box siya, wala siyang check sa gitna. You can use pre-tick checkboxes that state that the user agrees to your terms and conditions or automatically opts in to optional extras. So you cannot use that. You cannot use pre-tick boxes, especially if it's optional extras. Again, you go to the legitimate purpose, which I was discussing a while ago, consent. Consent should be unbundled. Okay, so unbundled consent. Hindi, ang terms and conditions, if you agree to the terms and conditions, hindi dapat kasama na mag-agree ka na maka-receive ng daily updates through email or through snail mail, whatever it is. No, you cannot connect automatic consent with other actions. You cannot connect it. It should be unbundled. Do not pre-tick boxes. And again, the last one, minimize the amount of data collected. Again, general data privacy principle ulit, proportionality. You should always practice to minimize the amount. Collect only what is necessary. Okay? Babalik ulit tayo dun sa the third, which is proportionality. The third data privacy principle, which is in our Data Privacy Act of 2012, proportionality. Collect only what is necessary. Diba? Sabi ko nga kanina, in the real world, we have this idea that we don't know today what we'll need tomorrow. So the natural tendency is talaga you ask for more data. And when this data sips into your web design or your app, it will end up with forms that ask for more, which is not more than what's strictly necessary or what's necessary to operate your business or use your system. And again, the dangers of that is if you are involved in a personal data breach, that the monetary cost is catastrophic. Aside from the loss of trust and the loss of reputation for your organization or agency or your company. Okay, next slide, please. So I would just like to give to you what we in the National Privacy Commission, we proposed the Data Privacy and Accountability and Compliance Framework. This is, in general, what your business needs to do, no? So that you'll be able to incorporate privacy in your design or in your privacy by default. So first, governance, you should appoint your DPO. This is for PICs and PIPs, especially PICs, the ones controlling data. This is the first level of compliance. You should appoint your DPO. And you should register your DPO with the commission. It's for us in the compliance monitoring division, we look at this as your number one level of compliance, and everything else follows. So you do risk assessment, you do privacy management program on a day-to-day basis. You operate with your privacy notice, you update it. Data security, you should have organizational, physical, technological measures. Data breach, you have a data breach management team. Third parties, there should be a legal basis for disclosure. You need to exercise data sharing agreements. You need to know cross-border transfers. Your human resources must be trained, no? Data privacy trained. If you want to do privacy by design or privacy by default, you need to train your employees on data privacy. Okay? Also, you have to do program review, continuing assessment and development. You do regular PIAs. Every time you do a system, you start it, you do a PIA, a privacy impact assessment. You review your contracts, you review your internal assessments, review your privacy management programs, and you do accreditations. And also, legal and ICT. So you need to be aware of the new legal issuances, legal circulars, the laws related to data privacy, not only in the Philippines, but if you do have your businesses abroad, also you want to expand your businesses abroad, you need to know not only legal and technological advancements in the Philippines, but also around the world. Sorry, next slide, please. So privacy impact assessment should be undertaken for every processing system of PICs or PIPs that involves personal data. One of the ways a PIC or PIP is able to demonstrate compliance with the DPA and IRR in related issuances. When you appoint a DPO and register it with the commission, that's the first level. When we do privacy impact assessment, that's the second level. So graduate ka na. When we check your compliance, nakapag-register ka ng DPO, nakapag-appoint and register ka ng DPO, nakapag-privacy impact assessment ka. So dalawa na, your level of compliance is level 2 ka na, level 2 compliant ka na. So that's a good thing. In case of breach, when a complaint is filed, the PIA shall be considered in evaluating the PIC or PIP's exercise due diligence in the processing of personal data. This is very important. When we check your compliance, we check your PIA. We always ask for if you conducted a PIA before implementing your system. If you did not, that's a clear indication that you are not compliant with the Data Privacy Act. So please keep that in mind. Okay, next slide, please. Security incident management policy, the creation of a data breach response team, security measures, personal data and data privacy policies, incident response procedure, mitigations of possible harms and negative consequences of personal data breaches, and especially compliance with the Data Privacy Act, its IRR and related issuances. So this should all be included in your security incident management policy or your privacy policy. Next slide, please. So personal data breach, what is it? A personal data breach of security leading to accidental or unlawful destruction, loss, alteration, unauthorized disclosure, or access to personal data transmitted, stored, or otherwise processed. So what are the kinds of personal data breaches? We have availability breach due to the loss and accidental or unlawful destruction of personal data. We have integrity breach, which is due to the alteration of personal data. And we have confidentiality breach because due to the unauthorized disclosure or access of personal data. Okay, next slide, please. So you do have to these are the elements, no? The things if these three are present, then you need to notify the NPC and the data subject 72 hours, within 72 hours after knowledge of the breach. When a personal data involves sensitive personal information or it may be used to enable identity fraud, if it is acquired by an authorized person, and if it would give rise to the real risk of serious harm or your ROSH, real risk of serious harm. So kung lahat ng tatlong to ay check, it is mandatory that you notify the NPC and the data subjects within 72 hours. So yan yung iniiwasan natin. So kung we do privacy by design, maiiwasan natin ang in this period in time when technology is booming, talagang yun na yung ginagawa natin. We use technology in our everyday lives. Also, there are a lot of masasamang elements, the bad elements that the hackers and those who would like to steal personal information, personal data, are always ready, no, to catch you off guard. So if you do privacy by design, again, I want to emphasize this, if you do privacy by design in your operations, if ever talagang sobrang galing ng hacker, at least ma-minimize mo what yung possible na cost and yung mangyari sa'yo. So, di ba, proactive tayo, not reactive. Again, next slide, please. So, finally, I'm sorry I exceeded my time, but I would want to emphasize privacy by design is a best practice. Privacy by design means considering privacy from the beginning of a project and integrating it into your system of operation. It is not a security practice or tool to be added on later. Again, we should be proactive, not reactive. Privacy by design. Getting it right means encouraging an organizational culture dedicated to acknowledging and respecting the value of personal data both to your company and to your customers. Yeah. So with that, with my whole team from, I think this is my last slide. So on behalf of my whole team in the Compliance and Monitoring Division, who regularly checks your compliance to the Data Privacy Act, through compliance check. We thank you for listening to our lecture for today, and I hope you get to have to build knowledge on these topics as we go on further to the topics by the next speaker. So thank you very much, and good morning, everyone.
Thank you very much, Attorney Milanes, for providing an overview of the DPA and the NPC in building trust in the age of digital transformation. Now that we know the technicalities of the DPA and the NPC's strides in ensuring compliance with it, let us now dig further into the contractual agreements and learn how to balance privacy with data sharing. Once again, may we call on Sir Jansen to introduce the next speaker. Sir Jansen?
Thank you, Sir Jed. It is my privilege to welcome our next speaker. Attorney Ivy Grace Villasoto, the OIC Director of the Privacy Policy Office, joined the Commission in October 2016. She obtained her Bachelor of Arts degree major in Public Administration from the University of the Philippines in 2004 and her Bachelor of Laws degree from the Far Eastern University in 2009. She has been in the practice of law since 2010. Prior to joining the Commission, she was a Director for Tax Services at SGV & Co. as a member practice of Ernst & Young Global Limited. Again, Director Ivy Grace Villasoto, you may have the floor.
Thank you, Jansen. Good morning, everyone. So I'll be discussing about contractual arrangements this morning. So I hope everyone can see the slides na. So contractual arrangements, balancing privacy with data sharing and other related transfers of personal data for personal data processing. So briefly lang naman to, a few slides lang on data sharing, on outsourcing, as well as yung recent na ASEAN MCCs which was adopted earlier this year. So siguro, key considerations po, as discussed kanina ni Attorney Ram, na-discuss niya na yung provisions on the DPA and the IRR and some of the issuances of the NPC. Dito naman on contractual arrangements and agreements, kailangan natin i-consider itong the following factors. So whether a system processes personal data. So ito madalas pa din namin tong natatanggap na tanong kasi minsan, some of our stakeholders are not sure whether the DPA applies to their processing. So titingnan natin kung yung sistema ba ninyo, yung apps ba ninyo really processes personal data. So kanina na-discuss ni Attorney Ram kung ano yung personal data. So there's personal information, sensitive personal information, privileged information. If your system does not process those, hindi siya nagpo-process ng personal data, then probably hindi nag-a-apply yung Data Privacy Act of 2012 and the issuances of the NPC. So if your system processes halimbawa statistics, aggregate data which cannot pinpoint a particular individual, then that is not it's not processing personal data. Hence, the provisions of the DPA, IRR, and issuances of the NPC will not apply to that processing activity. Tas kailangan natin ma-determine, if you've determined already na personal data yung pinoprocess nyo, ano-ano ba yung mga personal data na pinoprocess? So ano ba yung types? So is it just personal information? Is it sensitive personal information? Kasi as discussed din earlier ni Attorney Ram, merong specific provisions which apply to sensitive personal information. And siguro alam nyo na din na mas mataas yung penalty under the law if sensitive personal information is involved. Another key consideration is you determine the roles. So sino ba yung PIC, Personal Information Controller, saka sino yung PIP, Personal Information Processor. Kasi minsan talaga nagkakaroon ng areas wherein we cannot determine kung ano ba talaga yung particular duty or responsibility ng isang entity dito, isang tao dito. Is it a PIC? Is it a PIP? So yun yung magandang mapag-aralan, matingnan kung ano yung mga roles ng mga involved na parties to a contract or to an agreement. And the last one, so pag na-determine na natin kung sino yung PIC and PIP, i-determine natin kung ano yung proper contracts or agreements to be executed. Kasi may mga certain, katulad ng data sharing, mamaya in the later slides makikita natin, it's supposed to be dapat ang parties lang doon ay PICs lang. So yun, kailangan nating ma-determine kung ano yung proper contracts and agreements to be executed. On data sharing, siguro aware na kayo, may bago tayong circular. It was issued late last year, Circular 2020-03 on data sharing agreements. So this superseded yung 16-02 and some of the provisions of the IRR on data sharing. It's defined as the sharing, disclosure, or transfer to a third party of personal data under the custody of a PIC or one or more other PICs. So yan, specific dito, kailangan parties to a data sharing arrangement or agreement would only be the PICs. So dapat na alala niyo yung definition kanina ni Attorney Ram kung ano yung PIC tsaka PIP. Data sharing agreement is a contract, a joint issuance, or any similar document. So depende, hindi naman po strict na yun ang title ng ating agreement. It's a DSA or a data sharing agreement. Most of the DSAs that we've encountered, we've reviewed, ang title nila MOA and Memorandum of Understanding of Agreement, etc. So not necessary naman na it's titled data sharing agreement. So it's a contract, joint issuance, or a similar document. It sets out the obligations, responsibilities, and liabilities ng mga PICs, okay, na yung parties doon sa agreement na yon, in the transfer of personal data. And it includes the implementation of safeguards. Of course, syempre kasama dyan yung pag-uphold ng rights of the data subjects. So itong mga to, makikita naman siya doon sa ating Circular 2020-03, which is available in the website. Pero i-run through ko yung mga common na na-receive namin na questions on data sharing. So one of the questions we receive, yung compliance ba namin, so whether nasa private sector ka or government, if you are required to comply with other laws requiring yung submission or sharing ng personal data, is it a violation of the Data Privacy Act? Syempre, no. So if there's a particular law requiring you to submit, may mga reportorial requirements, monthly man yan or quarterly or what have you, may batas, may regulation, existing siya, hindi siya na overturn, hindi siya di siya na-declared void ng courts. So you have the obligation to follow that. So it has the DPA, sabi sa declaration of policy nito, it has the twin task of protecting the right to privacy while at the same time ensuring free flow of information. So the law, the DPA, should be read together with other existing laws. It's not meant to prevent the government or the private sector when necessary. Ito specific to the government when it's necessary to fulfill your mandate. So if a private sector kailangan mag-comply doon, private sector company needs to comply with the particular law, kailangan nilang sundin yon. So hindi po excuse yung Data Privacy Act. Okay. Ang lagi natin tatandaan siguro dito, parang it's in a way na established kasi na may legitimate purpose. Ang nagiging issue most of the time, as mentioned din ni Attorney Ram kanina, is yung proportionality as well as yung transparency ng data processing activities. If involving yung sa processing ng personal data with respect to requirements of a particular law or regulation. Another question that we are asked is ano yung possible lawful criteria for processing or for data sharing specifically under the DPA. So dito, pipili kayo kung saan kayo nagfo-fall, Section 12 or 13 ba. Yung 12 applies to personal information, Section 13 applies to processing ng sensitive. So if you're data sharing sensitive personal information, you have to determine consent-based ba siya? Is it sharing which is based on a law, sharing which is for defense of legal claims, etc. So, yun, kailangan nyo siyang ma-determine kung, yun nga, as mentioned earlier in the earlier slides, kailangan natin i-determine kung ano yung personal data na pinoprocess natin so that we know kung ano yung mga particular provisions ng DPA ang mag-a-apply dun sa particular personal data processing activity na yon. And to emphasize lang, hindi laging consent-based. So, madami tayong pwedeng pagpilian dito. So, pwedeng kontrata, pwedeng compliance with the legal obligation, legitimate interest, etc. So, ayan, kailangan tanongin nyo yan sa mga data protection officers nyo. Kung hindi kayo sure, halimbawa, kailangan may consultation yon with your DPOs kung ano ba talaga yung processing activity natin. Is it based on what particular provision under sections 12 or 13 of the DPA? Another question is ito, on consent. In what instances do we need consent of the data subject? So, yun nga, if hindi kasi siya laging consent-based, as mentioned. So, consent, kukuha tayo ng consent if it's required by law. So, kasi may mga laws na nagre-require ng consent. Or when consent is the most appropriate lawful basis. So, paano natin ma-determine kung siya pinaka-appropriate? Siguro titingnan natin yung relationship natin, obviously, with the data subject. Usually, sinasabi, kapag may imbalance between the data subject and the PIC, parang mahirap i-prove na nagkaroon ng freely given consent. So, yun din yung mga titingnan natin na factors kasi consent as defined is it should be freely given, it should be specific, it should be an informed indication of will. So, kailangan mong masabi, kailangan mong ma-prove na nakakuha ka ng valid consent kapag nandun yung freely given, specific, informed indication of will. So if there's an imbalance sa parang may power imbalance halimbawa between a data subject and the PIC, parang mahirap yung masabi na it's freely given, 'di ba? So kaya nga dito may nota ko dito na we should not get consent if it is not appropriate in relation also to the purpose of processing. Kasi meron kaming mga nababasa, naririnig na pag nag-withdraw ng consent, nagpapatuloy pa din naman yung processing. So, ibig sabihin, at the very beginning, baka aware na si PIC na hindi naman pala consent-based yung kanyang processing. Kasi alam niya na kahit mag-withdraw or mag-object si data subject, magpapatuloy pa rin siya. So, meaning, hindi dapat kumuha ng consent kung hindi naman pala consent yung proper or the most appropriate lawful basis for processing. So mamaya may mas in-depth, I think si Kelvin will have a more in-depth discussion on consent as well as on privacy notices. So madi-discuss niya siguro ito. On how much personal data can we share? Ito din, lagi din kami tinatanong, hindi kasi kami yung magde-determine kung ano yung kailangan ng PICs. So kayo dapat yung mag-determine kung ano yung kailangan nyo vis-a-vis your purpose. So ang dapat nyo i-consider, as mentioned by Attorney Ram kanina, yung proportionality nga. So, yung sakto lang, yung tama lang. So, ang sabi sa IRR, dapat adequate, relevant, suitable, necessary, not excessive in relation to the purpose. So, yan yung dapat nyong i-share lang. Yung sasakto lang doon sa purpose nung ka-share nyo halimbawa. So, we consider always the principle of proportionality. We consider always data minimization when we engage in any personal data processing activity. So, do we always have to execute a DSA or a data sharing agreement for all sharing arrangements? So, dun sa bagong circular sa 20-03, DSAs hindi na siya mandatory, it's optional. So, ang nakalagay po dun sa circular natin, the execution of a DSA is a sound recourse. It demonstrates accountability or accountable processing of personal data as well as good faith in complying with the requirements of the law. So, ang nangyari kasi, it's parang nabago yung view. Before kasi, pag hindi ka nag-enter into a DSA and you're required to enter into a DSA, it's possible na ma-penalize ka. So now, ang naging parang nagbago na yung tactic kumbaga ng commission. Ang ginawa na ng commission is that ini-incentivize na natin ngayon yung pag-enter into a data sharing agreement. So meaning if you have a sharing arrangement tapos dinocument mo siya through a DSA, the NPC shall take this into account where a complaint is filed pertaining to such sharing or during an investigation or in the conduct of compliance checks. So parang naging plus points siya na may incentives to enter into a DSA. Also, we emphasize dito na DSAs need not be reviewed or approved by the NPC. Although we have that function to assist in the review of DSAs, pero hindi po siya required. So, pwede nyo pong ipa-review sa amin, pero hindi po siya required under the DPA or the issuances of the NPC. Kasi baka mamaya po magkaroon ng issue na nag-aantayan po tayo sa kung urgent po ba yung sharing arrangement, etc. And you're thinking na we still need to get NPC clearance on this. Wala po kaming ganon, hindi po kami nagki-clear. Lang po kami, nagpo-provide lang kami ng suggestions and recommendations on how to improve your DSAs. Pero it's not really required. So we assume na you've taken into account the provisions of the DPA, IRR, the issuances of the NPC when you enter into your DSAs or any other sharing agreements or arrangements. Under the circular, ito po yung the usual na makikita po on the contents of a DSA. Siyempre po, dapat nandyan yung purpose. Pag yung purpose, sasabihin na po natin specifically kung government po na sharing, kung ano yung mandato na involved, ano yung particular law, data, kung private sector sharing, dapat i-identify natin kung ano yung lawful criteria for processing natin. So ano-ano yung personal data na sinishare, sino yung parties, obviously dapat nakasulat dyan kung sino yung PICs involved, the term. So ito din po yung one of the changes from the 16-02 to the 2020 issuance. Yung term po kasi before is limited to 5 years pero can be renewed or extended. This one, hindi na siya nag-prescribe ng particular term pero ang nakalagay po doon dapat may specific term. Hindi pwede yung indeterminate term. So tapos nandiyan pa rin yung provisions on yung operational details of the sharing. Yung security measures, yung safeguards na dapat i-implement ng parties to secure the shared personal data. Siyempre, nandiyan po yung rights ng data subjects na dapat may mechanisms in place, yung mga PICs, the parties, enter into that particular sharing arrangement, yung retention and disposal of the shared personal data, as well as accountability. Dito, meron ng particular requirement na kailangan pipirma as witness yung data protection officer ng parties. So yun, bago din po yun dito sa circular 2020-03. Sa outsourcing naman, so moving on sa outsourcing, ito naman yung agreement, arrangement or personal data processing activity na kumbaga dinidisclose or tina-transfer ang personal data by a PIC to a PIP for processing. So yun, dapat alam natin yung difference niya with data sharing earlier. So outsourcing, kapag si PIC, halimbawa, hindi niya, ay napag-decidean niya na mas, mas economical or mas for a business, mas maganda na i-outsource ko na lang to kasi hindi ko na kayang gawin, etc. Kung ano man po yung reason. Na sa isang third-party service provider, halimbawa, ang tawag nga natin doon is the PIP, the processor, Personal Information Processor, na siya na lang ang mag-process ng personal data na yon. PICs, under the IRR, PICs are expected to use contractual or other reasonable means to ensure na syempre may safeguards dun sa transfer and processing ni PIP, confidentiality, integrity, and availability of the personal data processed, and prevent its use for unauthorized purposes, and generally, syempre, magko-comply with the provisions of the DPA, the IRR, and other issuances of the NPC. Okay. Section 43 po ito ng IRR ng DPA. Ito lang, kasi nga, minsan talaga, hindi, until now, kahit ngayon, medyo may nakakalito pa rin kung sino ba talaga si PIC, tsaka sino ba si PIP. So, merong recent na guidelines si European Data Protection Board or the EDPD, 2020 siya na guidelines on the concept of controller and processor in the GDPR, which is very similar din naman nung atin sa DPA. So, sabi doon sa guidelines na yon, 2 basic conditions qualify for qualifying as a processor, as a PIP. So, it is a separate entity in relation to the controller, and that it processes personal data on the controller's behalf. So, yun yung 2 basic conditions. So, separate entity in relation to the controller sa PIC, and that the PIP processes personal data on the PIC's behalf. Sabi din dun sa guidelines, the processor, the PIP, must not process data otherwise than in according to the controller's instruction. So similar din dun sa requirement natin under the DPA IRR and other issuances of the NPC, si processor, si PIP ay nag-a-act lang based on the instructions, clear instructions sa kanya ni PIC. Pero syempre, the PIC's instructions, sabi din dito sa guidelines, may still leave a certain degree of discretion on the part of the PIP on how to best serve the PIC's interests, allowing the processor to choose the most suitable technical and organizational needs. Sabi din dito, if the PIP goes beyond the controller's instructions and starts to determine its own processes and means, so it's possible na makonsider siya na PIC na din. So yun po yung mga tatandaan natin with respect to the concepts of controller and processor vis-a-vis entering into an outsourcing agreement or a subcontracting agreement. Sa sections, tingnan po natin yung sections 43 to 45 ng implementing rules and regulations. So medyo mahaba siya dito. I think section 44 to, yung mga stipulations kung ano yung obligations ng PIC, ng PIP, more specifically dito sa 1 to 9 na to. I-check nyo na lang if your current outsourcing agreements have these provisions or kahit pa paano na embody ito. Kasi dapat nga, ang sabi dito sa B1 na to, that the PIP shall only process upon the documented instructions ni PIC, including transfers to another country or international organization, etc., unless the transfer is authorized by law. So meron din obligation of confidentiality dyan. The obligation to implement, syempre, appropriate security measures. So what is appropriate? So titingnan natin dyan yung factors to consider would be ano yung type ng personal data pinoprocess, gaano kalaki yung organization, yung costs ng implementation, etc. So meron din provisions ang DPA on the factors to consider on what is appropriate security measures. So dito din meron din prohibition on engaging another PIP without prior instruction from the PIC. Okay. Ayun nga, technical organizational measures to fulfill the obligation and respond to requests from data subjects relative to the exercise of their rights. So, dapat ilagay nyo yun dun sa, the PICs here in the audience, dapat in your contracts, malinaw yon na dapat merong obligation ang PIPs natin to assist us just in case kailangan nating assistance from them with respect to mechanisms whereby we can enable the exercise of data subjects and their rights. Data subjects' rights, okay. So ano pa ba yung mga nandito? On siguro provisions then on the return of the personal data to the PIC after the services, etc. So retention and disposal, nandyan siya. Ayan, so meron ding make available to the PIC all information necessary to demonstrate compliance with the obligations laid down in the Act, etc. So ito po ay nasa section 44 ng IRR of the DPA, which you can check vis-a-vis yung mga current nyo na outsourcing arrangements or subcontracting agreements so that you can have additional guidance kung enough na ba yung current contracts nyo, kailangan nyo ba siyang i-review ulit at i-check kung kailangan nyo magdagdag ng certain provisions so that you are compliant with the provisions on outsourcing ng IRR. Moving on dun sa ASEAN Model Contract Clauses or the MCCs. So ito kasing ASEAN MCCs and the Data Management Framework, if I remember, na-approve siya or sometime early this year, January. And then the NPC, the Commission decided na mag-adopt din tayo. I-adopt din natin siya through a local advisory, itong ASEAN Model Contract Clauses. So these MCCs are developed for voluntary adoption. The contractual terms and conditions may be included dun sa the usual nyo na agreements or the binding legal agreements between the parties or entities transferring personal data across the ASEAN member states. So sino bang nasa ASEAN? So tama ba si Brunei, si Malaysia, Indonesia, Singapore, yun, basta lahat ng members ng ASEAN, kung meron tayong transfer of personal data inter ASEAN member states, pwede nyong gamitin itong MCCs na ito. So these are templates setting out the responsibilities, required personal data protection measures, and related obligations of the parties. So siguro i-check nyo din po yung aming advisory, yung 2021-02 on guidance on the use of the ASEAN MCCs and the ASEAN DMF or Data Management Framework. So yung ASEAN MCCs, meron siyang portions doon, yung mismong document, may transfer relationship siya, which is similar din dun sa atin nga, controller to processor, so yun yung outsourcing, and controller to controller, so yun yung data sharing. So yan yung mga transfer relationships whereby you can use the template ASEAN MCCs kapag nagta-transfer kayo within the ASEAN member states ng personal data for processing. So medyo maliit, screen capture ko lang kung ano yung itsura ng mga template clauses. So yan usually, yan yung makikita natin dun sa ASEAN na document. So there's controller to controller transfer and then controller to processor transfer. So ang sections niya, nakalagay dun yung definitions, merong obligation obligation of the data exporter, so kung saan manggagaling yung data. Then obligations of the data importer, kung saan papunta yung data. Yun yung generally yun yung na dun sa ASEAN MCCs. Tapos sa dulo merong portions on parang other commercial clauses, which is not really na on data protection or data privacy related, pero more on the other usual clauses na parang dispute resolution, anong law mag-a-apply, etc. So yun po, meron din ganong portions dun sa ASEAN MCCs. So ito yung mga usual na nandoon na makikita natin. So may definition of terms. Yan, importante po yan na in your agreements, kung ano man po ang title ng agreement nyo, whether it's for data sharing, whether it's for outsourcing, whether you will use the ASEAN MCC template. So dapat may definition of terms para lahat ng parties are on the same page kung ano bang ibig sabihin nitong particular term na to. Lalo na pag mga technical terms, yan din yung usual namin kino-comment when we review DSAs na it's better na i-define nyo to 1, 2, 3, 4, 5 kasi minsan hindi naiintindihan. Baka yung parties mismo baka hindi sila nakakaintindihan kung anong ibig sabihin ng particular term na yon. So nandyan din yung ilalagay natin kung ano yung lawful basis for processing. So may provisions na ganyan dun sa ASEAN MCCs. The security measures that will be implemented, i-uphold yung data subject rights, cooperation with data protection authorities or other enforcement authorities. Meron din siyang provisions on data breach notifications, as well as provisions on retention of personal data, either controller to controller or controller to processor. So may mga ganong template clauses for these particular items. So yan, siguro i-emphasize ko lang that the ASEAN MCCs, hindi niya inamend ang DPA IRR and other related issuances of the NPC. Actually, pwede niyo po siyang gamitin to fulfill your obligations under Section 21 of the DPA. Ito po yung principle of accountability. As one of the contractual or other reasonable means to provide a comparable level of protection while personal data are being processed by a third party. So, either nga whether or not it's a controller PIC to PIC or PIC to PIP na processing, pwede nyo pong i-check itong ASEAN MCCs when you are going to transfer or have personal data processed halimbawa sa labas ng Pilipinas to the other ASEAN member states. Yun din, these are voluntary in nature. They do not amend the DPA IRR and the related issuances of the National Privacy Commission. And also, similar to the DSA kanina, hindi rin to required na ipa-review sa amin if you are going to use the MCCs or your if you will incorporate itong MCCs sa inyong mga other contracts and other agreements to be executed. Hindi po siya required to be reviewed or approved by the National Privacy Commission. I think it's my last slide. So if you have any questions, I'm not sure if we have an open forum later on or sa chat, I can try to answer your questions via the chat function. Yun lang. Thank you.
Thank you very much for that very concise discussion, Director Villasoto. I hope our audience is having a good learning experience so far. So kindly react thumbs up so that we know that you are still with us. Again, kindly react thumbs up po so we know that you are still with us. All right. All right, thank you for the reactions. So moving on, to discuss the best practices to electronic consent and online privacy notices, may we call Sir Jansen again to introduce our next speaker.
Thank you, Sir Jed. I think for the questions, just key in your questions in the chat. We'll have our NPC speakers this morning have a short question and answer before we proceed to our next topic in the mobile app privacy by Mr. Kevin Shepherdson later. So thank you, Sir Jed. So it is my privilege to introduce my teammate, our next speaker, Mr. Kelvin Magtalas. So he is an Information System Analyst 3 of the Data Security and Technology Standards Division of the National Privacy Commission. He takes charge of the systems analysis and designing and all matters related thereto. He is also in charge of conducting privacy impact assessments of new and revised processes and systems. Mr. Magtalas was a graduate of computer engineering from Bulacan State University. Before his affiliation in the NPC, he was a programmer at Reed Elsevier Shared Services Philippines Incorporated from 2013 until 2016. As a data privacy professional, he holds a CompTIA Security Plus certification, PECB ISO 27001 lead auditor, and PECB ISO 29100 lead privacy implementer certifications. He is also a current committee member and a Philippine representative to the ISO IEC JTC1, AC27, and WG5 that focuses on identity management and privacy technology standards development. where he submit comments, research, and review the drafts, revision, and technical reports issued by the said committee. He is currently one of the co-editors of 2 upcoming projects which can potentially emerge as international ISO/IEC standards, namely ISO/IEC 27557 Organizational Privacy Risk Management and ISO/IEC 27560 Consent Information and Record Infrastructure. Sir Kelvin, you now have the floor.
Thank you, Jansen. I'll be presenting consent best practices, particularly on online privacy notices and consent receipt and record, which would be primarily be essential for developing applications that act on personal data. So I'll be discussing online privacy notice, a brief description, and some information about consent, and the theory regarding consent receipt and consent record. For online privacy notices, first, I present the question, so what is the biggest lie in the internet? So in 2016, a paper published by Jonathan Obar and Anne Oldorf-Hirsch regarding the biggest lie in the internet, which is ignoring the privacy notices in terms of services of social networking site, wherein they created a fictitious social networking site named NameDrop, and they tried to research on whether yung mga members or registrants will read the privacy notice. So, yung based dun sa data nila, the users, at least 80% of the users, only used 1 minute or less in reviewing yung privacy policy, and almost 90% in terms of reading the terms and conditions. So yung terms and conditions and privacy policies that they used are modified version of the LinkedIn privacy policy, which includes which is about 7,977 words, and it is suggested to have an average adult to have read or understand the privacy notice about 29 to 32 minutes. So as you can see, medyo less 10% lang yung users na nagbasa ng 5 minutes or more. So it is said that yung privacy notices and privacy policies are ways to empower yung data subjects or PII principals with regarding on controlling their data and the services that they provide their data. So, yun, alam mo naman, marami tayong guilty dito sa pag-ignore ng privacy notice. So, privacy notice refers to a statement containing all the necessary information on the specific types of processing, which allows the data subjects to make an informed decision. So, actually, based sa law, dapat mag-provide si personal information controller or personal information processor. And one of the rights of the data subjects is the right to be informed. And yung elements niya should be a clear and concise language, and also considered yung targeted audience or yung targeted data subjects. So many organizations that provide personal data processing are using privacy notice or privacy policy consistently. So sa tingin nila, parehas lang yung privacy policy and privacy notice. Actually, it's different. For privacy notice, it's a specific statement, or it refers to a statement containing all the necessary information on the specific type of processing, which allow the data subject to make an informed decision. For privacy policy naman, refers to a privacy statement or a fair processing statement, which is a general statement made to the data subject that describes how the organization collects, use, retains, disclose, and personal data. So I think na-mention din ni Attorney Ram kanina yung privacy notice is a specific statement for the specific types of processing. So for example, yung isang fintech services, ito maraming guilty rin dito na yung pino-provide lang nila na privacy policy or privacy notice is yung privacy policy nila dun sa website, which vaguely describe yung actual processing nung pinoprovide ni fintech services. So lagi po natin tatandaan na different yung privacy notice and privacy policy. Yes, both silang pinapresent or binibigay kay data subjects. But si privacy notice provides a more specific description kung ano ba yung talagang ginagawa doon sa personal data or sa personal data processing na binibigay ni data subjects yung kanyang personal data. So yung objectives on providing privacy notices is provide privacy notice where it is required in a language appropriate to the targeted data subjects at a time that allows the data subjects to exercise consent, considering where it is easy for them to recognize. So usually, yun, pag nagda-download ka ng mobile applications or nagsusubscribe ka sa isang web application, yung ginagawa ng mga personal information controllers or personal information processor, binibigay nila yung privacy notice right before the collection of their personal data or right before where input their personal data to a web form. So yun po yung pinakamagandang practice in providing privacy notices. Some also provide their privacy policy at the footer. So kahit nung kanilang website, so kahit saan siyang page napunta, available yung privacy notices for the data subjects to read. So ito nga po sa mga pictures, yung mga example. I would also like to discuss yung international standard, which is the ISO IEC 29184, which is a joint project between ISO and IEC, which provides the information technology, online privacy notices, and consent. So this standard specifies controls, which specifies the content and the structure of online privacy notice, as well as the processes of asking for consent to collect and process personally identifiable information or personal data in the DPA terms from the PII principals or the data subjects. So an overview of the standards provides notice, contents of notice, so yung sa notice, yung main objective niya is to provide notice when it is required in a language appropriate to the data subjects at the time that permits the data subjects to meaningfully exercise their consent at place where it is easy for the data subjects to recognize, and with reference to provide with the data subjects to access supplementary materials such as yung terms and conditions dun sa services. It may also include prior notices and prior responses that they provided before. So dito sa section na to or sa clause na to, dinidiscuss or ini-state ng standard yung obligation na isang organization kung kailan ba talaga sila nagpo-provide kung kailan sila dapat mag-provide ng privacy notice. So ano ba yung appropriate expression ng privacy notice? So kung web application yon, dapat available ba siya sa web application or sa mismong website? For a mobile app, so dapat ba siyang i-hyperlink sa website or dapat mayroong privacy notice doon sa mismong application for easy access. Multilingual notice din. So considering yung, as I mentioned earlier, yung privacy notices could consider yung targeted data subjects. Whether kung magpo-provide ka ng privacy notice in an English manner, so lahat ba ng targeted audience mo or yung data subjects can understand English. So dito sa Philippines, medyo marami tayong dialect. So dapat natin ding i-consider kung dapat bang mayroong reiteration or translated versions yung mga privacy notices na pinoprovide natin kay data subjects. It also provide appropriate timing kung kailan pinipresent or kung saan siya ipipresent yung privacy notice. Most likely yung as a privacy notice, prior to any collection or any personal data processing, dapat ma-present yung privacy notice. Appropriate locations, yun kagaya po nung na-mention ko kanina, kung dapat ba readily available siya sa website. And appropriate form and ongoing references ko. Kapag nag-update tayo ng privacy notices, usually kahit updated na yung privacy notices, yung previous version wala na dun sa website. So kung gustong gawin or kung gustong i-access ni data subjects or ni regulator yung mga previous website para malaman yung difference. So dapat available pa rin po siya. So contents of a notice, discuss ko later yan. But mainly yung objective dito sa contents of notice is ano ba yung dapat lamang na isang or ano ba yung dapat contents na isang online privacy notice. So for consent, yung objective niya is to ensure that the organization shall obtain consent where it is necessary. It also discusses kung to provide guidance kay organization on whether consent is the appropriate lawful basis for processing. And ano ba yung guidance in terms of informed and freely given consent. And providing information about which account yung consent na binibigay ni data subject. So applicable to for services or software services wherein yung isang data subject could provide or could create multiple accounts. So yung consent na binibigay ba niya dun sa isang services na yon is for one account lang or for multiple accounts. For change in conditions, ang dinidiscuss naman dito is kung kailan dapat mag-renew ng consent or kung kailan dapat mag-renew din ng privacy notices. So for the contents of notice, dito dinidescribe yung mga requirements or and guidance for ano ba yung dapat maging laman na isang online privacy notices. So first one is yung purpose description. So ano ba yung purpose ng service, ng web app or mobile application na pinoprovide ni organization. And way or manner ng presentation of description. So yun nga, kung mobile or web application ba siya. Identification ng PIC or Personal Information Controller na nagpo-provide ng service or nagpo-control ng service. Personal data collection. So ano ba yung mga personal data na kino-collect or pina-process ng service na pinoprovide natin ng notice. So what is the collection method? So is it a web form or is it from other or third party? Timing and location of consent. Methods of use, kung saan gagamitin yung personal data na ipaprocess. Ito, geolocation and of identification ng jurisdiction, specifically dun kung saan ini-store yung personal data. So pwede siya mag-fall kung outsourcing or gumagamit ng cloud si service provider or sa PIC. So dapat naka-mention dun sa privacy notice kung anong jurisdiction ba may bibigay yung kanilang personal or matatransfer yung kanilang personal data. So if applicable, ano yung third-party transfer kung sinong organizations or kani-kaninong organizations ma-disclose yung kanilang personal data. Specific information regarding the retention period. Of course, yung data subjects' rights on how can they exercise it. Manner or procedures kung kailan sila magbigay ng inquiry and complaint about their personal data. So ito, information about accessing the choices made for consent. So if consent-based yung service or yung personal data processing, so yung privacy notice so describe information about yung sa consent na binigay ni data subject kumpara sa processing or ano mga services lang yung allowed sa pagbigay niya ng consent. And basis for processing, again, kung consent or merong contractual obligations. And yung pinaka-underrated na content requirement is the definition or explanation ng mga risks involved in terms of sa pagbibigay ng consent or sa mismong personal data processing na yung privacy notice is about. So for consent, just read yung definition niya sa DPA. It refers to any freely given, specific, informed indication of will whereby the data subjects agrees to the collection and processing of personal information about and or relating to him or her. So consent shall be evidenced by written, electronic, or recorded means. So it may also be given on behalf of the data subject by an agent specifically authorized by the data subject to do so. So yung kanina pa namin mention yung informed decision or informed consent. So consent is only considered to be informed if there's an evidence that the data subjects has been provided a clear and understandable privacy notice. So as you can see, if consent-based or yung processing is primarily kailangan ng consent, so yung importance ng privacy notices or pag-provide ng privacy notices kay data subjects is very critical. So hindi siya mako-considered na informed if walang evidences na nagbigay ng privacy notices or some description of the information about the processing. So na-mention ko rin kanina yung renewing of consent or kung kailan ba pwede magbigay ng consent ulit. Specifically kapag nag-provide na si data subjects ng consent. So ito yung mga sample scenarios. So for example, si PIC, change na yung purpose ng personal data processing. So definitely yung consent na binigay niya dun sa una is para dun sa original purpose. So recommended na mag-renew ng consent for this situation. So if there is a substantial organizational change, for example, nag-change ng owner and different niya na yung views niya in terms of the personal data processing and change of business. If mayroon changes dun sa PII na kinokollect, so dati, kung dati 8 personal data lang yung kinokollect and nagbago from 8 naging 15 na. So dapat magkaroon ulit ng consent or manghingi ulit si organization ng consent kay data subjects. If may changes dun sa collection method, so kung dati previously nanggagaling siya directly kay data subject or ang ginagamit nating collection method is through a web form, and now through web application na or different application na yung collection method natin. So definitely dapat consent. If mayroon changes din sa personal data transfer and mayroong na-extend or may changes dun sa retention period. So ito naman po yung some example of cases of electronic consent. Or in the University of Wisconsin, particularly yung Health Sciences Institutional Review Board, so meron silang document in terms of providing electronic consent or ano ba yung recognized nila as electronic consent. So basahin ko lang yung based dun sa kanilang policy. So electronic documentation of consent may be used when researchers conduct the consent process with participants in person, as well as when potential participants are not physically present during the consent process. So in either situation, the consent process itself should be defined to ensure that participants are adequately informed about the research and can easily ask and get answers to questions and recognize the participation is voluntary. So si Health Sciences Institutional Review Boards po kasi is so nagko-conduct sila ng research wherein they need the consent of the data subjects, and because of the pandemic, so yung consent forms nila or which is usually the manner of their way of collecting consent. So binago nila into 3 sample cases. So for them, yung electronic signatures or may digital signatures si data subject na sinubmit sila sa kanila is considered as electronic consent, or fax copies of the signed consent forms, or email copies of the consent forms. And ito, online consent, which is yung I agree button. Usually familiar tayo dito. Ito yung isang manner in terms of having an electronic consent. So actually meron tayong nakikita na natin yung consent management or consent management application all throughout sa mga services na pinoprovide or ginagamit natin. For example, kay Google, meron siyang sa account settings niya, makikita natin yung mga third-party transfers or third-party applications na merong access kay Google account natin. So, tingnan niyo lang po siya sa manage account and privacy settings. Andun yung mga services o mga third-party services which wherein merong access sila sa atin. So, in a way, ito yung parang consent management portal. Also yung kay Apple services, meron din siya sa kung ano yung mga subscription. Kung siyempre usually pag nag-subscribe tayo sa isang services, tinatanong din yung consent natin. Kung ibibigay ba or nag-agree ba tayo dun sa kanilang terms and services. So which takes me to the next topic, yung consent receipt and record. So yung nakita po natin dito is yung parang consent management portal wherein specific dun sa services na binibigay or sa services na minamanage ng Google account or ni Apple. So, which is, for example, kung Google account lang yung ginamit natin dun sa services na pinagbigyan natin ng access dun kay Google account, yun lang yung kanilang mamamanage. Ganon din kay Apple. So yung consent receipt and record is the idea to how to interoperable yung consent management. So imagine in a few years, you have consented to 500 services. So as a data subject, so paano mo mamamanage or paano mo makikeep track yung services na pinagbigyan mo ng consent? Yes, yun nga po, through a consent management portal. But using consent management portal, it is only limited to the Google services and Apple services. So, kung paano yung mga services na binagbigyan nyo ng consent or personal data wherein hindi mo ginamit si Apple or si Google. So, now what? So a solution is to have your own privacy dashboard and to manage your data rights and act when you choose. So kapag ayaw mo nang ibigay yung consent or yung personal data mo sa isang service or natapos na yung purpose niya for your point of view, hindi mo na kailangan umaccess kay Google or kay Apple para lang ma-terminate yun. So you can access it by yourself. So yung the vision regarding sa privacy dashboard is to have an open ecosystem of privacy dashboard and tools requires standard data formats in order to be viable not just for the data subjects but also for other organizations. So the vision is to standardize yung consent receipt. Standardized consent receipt is issued to the data subject whenever they consented to personal data processing. Will help them to enable a product ecosystem that assists the data subjects to exercise their privacy rights. So yung consent receipt is similar to the receipt wherein kapag nag-grocery ka or nagpunta kang market na nag-purchase ka na isang product or any item, binibigyan ka ng receipt. So why do they give you the receipt and why do you keep the receipt? So if merong problem dun sa product or item na binili nyo, pwede nyo siyang ibalik. And yung receipt yung parang serves as a record for the data subjects or dun sa buyer para kung gusto niya isole or papalitan yung item or product na binili niya. For the data privacy perspective, yung consent receipt is a record that will be provided kay data subject kapag gusto niyang makita yung record kung anong services ba yung binigay niya, anong personal data ba yung binigay niya dun sa services kay organization. Yeah, as I mentioned earlier, consent is only considered to be informed if there is an evidence that the data subject has been provided a clear and understandable notice So it needs to be freely given without the data subjects perceiving any form of coercion or compulsion according to ISO 29184. So one possible approach to document the consent is the use of consent receipts, specifically on electronic services. So consent receipt, the common format of linking notice requirements to a usable format, focus on legal requirements for consent and privacy notices. The infrastructure that enables effective governance, not just for the regulators, but also to the PICs or PIPs. And opens the market for innovation in personal data control, specifically for the data subjects. So this initiative was started in 2015 by the Cantara initiative. They started a working group on a document about consent receipt specification to provide an interoperable consent receipt specification information structure for organization that provides personal data processing or personal data services. You want to access yung specification here. It's freely available. So the consent receipt is the data subject's copy of the personal data processing transaction. So as I mentioned earlier, just like when we purchase from a store, we are provided a receipt. So yun din. It became a basis for an ongoing project in ISO about consent record information structure. ISO IEC, Technical Specification 27560. It's an ongoing project and hopefully it could be published around 2023. So yung main objective or yung main definition of consent record, record of the consent of the interaction of the data subject with the PIC. Yung difference niya with consent receipt is provided to the data subject and yung consent record is recorded by the PIC or the PIP. I think this will be the last. Yung benefits ng having or implementing yung consent receipt and consent record management for the data subjects is provides knowledge and control regarding the services and the personal data they provide to an organization. Consent management before and during and after the providing the consent. For PICs and PIPs, compliance and trust. And it also provides a privacy by design approach wherein it enables yung data subjects and provides a manner or services, the organization wherein the data subjects can exercise their rights. It makes it easy, cost-effective for organizations to comply with the law. For regulators, it provides also easy for oversight and management functions on PICs and PIPs and provides the flexibility to regulate and enforce regulations according to requirements. And for everyone, improving economic performance of policy solves many issues in identity management. I think this is the last slide. So thank you.
Thank you very much, Mr. Magdalas, for that comprehensive discussion on electronic consent. Next, we will now have a better understanding of the mobile app privacy by design approach. To introduce our speaker, once again, may we call on Sir Jansen, the policy advisor of the technology sector and key privacy theme leader for bigger tech and social media. Sir Jansen?
Okay, before we proceed to our next session, we have a two-part session for our mobile app privacy. So I think we have time to sneak in some substantial questions in the chat. So in the interest of time, we have screened the questions and I think we have space to introduce one question for each resource speaker in our NPC lineup. So the first question, I think I addressed this to Attorney Rainier Milanes. So a question posed by Mr. John Roy Robert Real Jr. Other than those in 16-03, what are the other factors that the NPC are considering in ascertaining whether personal data subject of a breach would amount to those that would enable identity fraud?
Well, sorry. Well, basically, it's we use real risk of serious harm to data subjects. So if you think that there is a possibility of real risk of serious harm to the data subjects, then that's one key factor that we would want to consider in the evaluation of the data breach notification. Sorry.
Okay, thank you for that response, Attorney Ram. And we will ask Director Ivy. So there's a question posed by Ms. Sharon So. Hi, Attorney Ivy. If a PIC transfers personal data to a PIC or PIP outside of PH borders, will the privacy laws of other country also apply for the PIC? Also, what data subject rights will be followed? Those indicated in the DPA, those indicated in the privacy laws of the other country, or both? Thank you.
Yun nga, thank you Jansen, thank you Miss Sharon. Dito kasi, if transfers to other with outside of PH borders, okay, yung law natin, may extraterritorial application siya. So, kapag Filipino data subjects are data are being transferred, being processed outside of the Philippines, it's possible na ma-apply natin yung DPA doon sa labas. Pero as to yung application din nung other laws of the other jurisdiction dun sa PH, sa Philippine PIC, kailangan nating i-check kung ano yung scope ng law doon sa jurisdiction na yon. As to data subject rights, it's possible na ma-enforce din natin yung data subject rights na nasa DPA, pero as to the applicable data subject rights provision naman din dung batas doon sa labas, kailangan din nating tingnan kung ano yung scope ng law na yon. Does that particular law also protect personal data of other citizens? Hindi ko lang sure eh. Kasi, pero meron naman kasing mga provisions na basta within their territorial jurisdiction, dun pinoprocess, protected then under that particular data protection law. But then we would have to check yung particular law on a case-to-case basis. Thank you, Jansen.
Thank you for that response and answer, Director Grace. So I think we proceed to the last question to be addressed to Mr. Kelvin. So what can you say about giving and collection of personal data, PI and SPI, through online forms, Microsoft, Google, etc. forms? Are these online forms safe? What can PICs do to ensure that the personal data being collected through online forms are secure and will not be available to some unknown cloud server? So I think, Sir Kelvin, you're on mute. Okay, so apologies, we're having some technical difficulties. But I think if I can answer the question for Sir Kelvin, he is having difficulty to unmute. I think we, of course, the National Privacy Commission, as you can see, we use Microsoft forms in the registration of these events. So what the steps that we make to ensure that that these forms are secure also is to, of course, we go through the settings and ensure that proper access controls are in place. So I think we have in configuring cloud services such as forms, they have pretty straightforward options that even non-technical people can configure. So as long as this information are restricted, for example, if you created a form that is publicly accessible and the filled out forms can be extracted publicly, then we have a problem, right? But if it's properly secured and information filled out by registrants cannot be directly obtained, so then I think we're just okay. We're okay with that because any technology, the NPC does not condemn or does not restrict any technology so long as we have a successful and good configuration or use of it. So I think.
Sorry,
Okay. We
a difficult. I was disconnected. Sorry. What was the question?
So I tried to answer the question addressed to you, but the question was, is it safe to use MS Forms or Google Forms online? So we would love to hear your inputs on this.
For regarding the safe inclination, whether yung Google Forms and Microsoft Forms are safe, as long as the data or personal data recorded as well as the consent recorded are well managed and well protected by the personal information controller or the organization that is asking for the consent, is viable naman. Ang nakalagay naman po sa law is yung in terms of evidence in consent, it should be recorded whether manually or electronic means. So, yun.
Okay, thank you for that response, Sir Kelvin. We have pretty much more questions, but in the interest of time, I think we would have to proceed in the next program. We'll just ask our resource person to respond in the chat for the other questions, right? So thank you. So moving on to our final session this morning. So may I introduce our next speaker. So our next speaker is Mr. Kevin Shepherdson, the CEO and founder of Straits Interactive Limited. A specialist in data privacy platform solutions and professional services in the ASEAN region. Mr. Shepherdson is also the international author of the 99 Privacy Breaches to be Aware of and a fellow in Information Privacy, FIP, the highest certification awarded by the International of Privacy Professionals, or IAPP. Besides having consulted for more than 50 listed and multinational companies in data privacy, he is also the authorized regional trainer of privacy certification and corporate governance related courses for IAPP, Singapore Management University, SMU, and Open Compliance Ethics Group, or OCEG. Having held Asia-Pacific leadership and management positions in his 20-plus years in IT security industry with creative technology, Sun Microsystems, and Oracle Corporation, Mr. Shepherdson brings his experience in business development, consulting, innovation, marketing, operations, and strategy to his current role. Throughout his corporate career, Mr. Shepherdson was a multiple award winner of both Worldwide and Asia-Pacific Employee Excellence Awards, which includes Marketing Excellence, Marketing Intelligence, and Technology Innovation. Mr. Shepherdson holds a Master's of Science degree in Internet and Media from Nanyang Technology University and a Bachelor of Arts and Social Sciences from the National University of Singapore. To formally launch his topic on mobile application privacy by design course, may we call on the Chief Executive Officer of Straits Interactive, Mr. Kevin Shepherdson. Sir, you have the floor.
All right. Good morning to all of you. I'd like to thank the National Privacy Commission for inviting me. I'd like to thank Commissioner Liboro for having me here. And again, a hello to all the members of MPC, and more importantly, hello to all of you in this session. I'm now going to share my screen, and in the next 2 or 3 hours, I'll be sharing about mobile app privacy. And this morning, I hope to talk about systems and processing risks. And I'd like to invite all of you to join me in this session as I take you through the information life cycle. Yeah, so as I go through it, I'm going to make it participative for all of you. So I'm also going to be using Mentimeter. All right, so here's what I'll be doing. So I want to start by covering a case study so that you can relate your application scenario. And I'm going to use that case study to then talk about the mobile app ecosystem, which all of you are familiar with, but I am going to be looking at it from a personal data DPA perspective, right? And you heard from members of the MPC where they were sharing with you the data protection, or should I say the Data Privacy Act, and what mobile app developers must do. But I am going to contextualize this for all of you. All right. So I want to start off, ladies and gentlemen, by asking all of you, and this is where I would like to use Mentimeter. And as I go through, just bear with me. I would like all of you to go and create a browser window, and I would like you to share with me your current profile, and I'm going to do my best to contextualize my presentation. So if I can invite everybody to go to menti.com and click on the code 22702562. Yeah. So let's see from where you folks are from. All right, thank you. So keep putting the entries in. I'll just only take maybe half a minute, right? So whatever time you all have, I will just capture your response. So as I can see, majority of you are DPOs, and a large number of you are from the software development or management team. All right, keep going. So I'm now at 57. So I'll wait until it cross over 100, because that will give me, ladies and gentlemen, a sample size of the audience that I'm having today. Yeah. So as we move into the 100 mark, you can see that majority of you are DPOs. So I am trying not to be too technical here, but at the same time, I would like the software developers to also be able to see where I'm coming from when we talk about mobile app privacy. Okay, so we are now at 100. I will pause at about 200, and I'm going to be continuing. Okay. Okay, so folks, what I've seen is majority of you, if I can summarize, are mostly DPOs, yeah, or COPs. And the second most popular segment is software developers and compliance professionals. Now, what I would like you to do is that for all of you who are also here from the mobile app development industry, okay, you can click on the next slide. And what I like to see from you is I would like to see your app monetization model. In short, if you have to do with an app, if your organization is using or have your own mobile apps, even outsourcing the mobile apps, I would like to look at your monetization model. How do you make money, ladies and gentlemen, with regards to the mobile app that you have created? So I've got 5 categories. I'm saying that you have no problem understanding it, right? So if you're doing targeted ads where you're working with advertising networks and you have ads in your mobile app, that's the first one. If you're selling your app, right, and you have a freemium model, that's the second one. Some of you may have activities, a subscription model, where when they join your app, right, they pay you an annual service fee. That will be it. So I'm seeing the subscription model. And finally, producing white label apps. Some of you are into development. You are creating the apps from your perspective. Now, it seems that majority of you are into e-commerce services, which I assume that your mobile app has got some platform where they can buy products or services. It could be a shopping platform, online shopping platform, or some kind of e-commerce service that you folks are offering. Okay, so I'm going to leave this up for the rest of you. I am aware that there are 500 odd, so this will be an excellent capture in terms of where all of you folks are from and how exactly you are making money from the mobile apps that you are creating. The fact is, ladies and gentlemen, in producing all these services, your purpose is to leverage, to monetize your mobile app, leveraging personal information, leveraging personal data, right? So I would like to now start my session by taking you through the world of the mobile app ecosystem. Now you can see that as far as you folks are concerned, that under the Data Protection or Data Privacy Act, they differentiate between a PIC and a PIP. What you are seeing here are the PICs, the Personal Information Controllers. And for you folks as the mobile app developer, right, and that's on the buy side, what happens is many of you work with agencies or what we call ad exchanges. This is the automated marketplace where they are the guys who connect the advertisers and the publishers to sell the mobile apps in real time. And these are the brands that will advertise. Some of them will also leverage agencies. Yeah. Now the DSPs are the demand side platform. Now there are sophisticated software, right, that make all the media buying decisions. And for many of you as mobile app developers, you do work with ad networks, right? And that's how we use, rather majority of you will have targeted advertisements in your mobile apps. Then obviously on the sell side, you have the publishers, yeah? This is the website or app that has a whole bunch of advertising inventory, yeah, that you sell. And we also have SSPS, which is the supply side platform. These are the publishers, and what they do is they automatically and they efficiently manage the selling of all of these advertisement inventory. So we are now here in this ecosystem where there are many PICs that process personal data either jointly, right, or on its own. But for all of you as mobile app developers, you have to know that you are part of a larger ecosystem. And that means knowing what is in the software that you make available, because there are privacy implications, right? And if I were to give you the bigger mobile app ecosystems, a lot of you would deal with many advertising networks where they provide you an API and SDK for you to incorporate into your app, because many of you will also be leveraging on targeted advertisements. And these ad networks, as you can see, will basically work with many other advertisers, agencies, and your mobile app is one of the many channels, which later on I'll be talking about trackers and permissions that are being used in your app. All right, so I will be taking questions later, but since I have 3 hours with you, I'd like to take the first hour before lunch to give you a perspective on what this ecosystem is. And I've created an imaginary, okay? This is an imaginary scenario where I invite the developers here, okay? This is totally fake, it is not real, I invented it, okay? So in my world, you guys are the experts here. I have an interactive toy that has IoT device inside, and it's connected to the mobile app, and you can see that it is connected. This is all fake, I created it, and there's an advertisement below. So you will notice that there are targeted adverts, and like what many of you have indicated earlier on, you also have an online shop where you can purchase stuff here. So in this application scenario, this toy has got text-to-speech, its eyes have got camera, and it's able to do speech recognition. And in my imaginary world, ladies and gentlemen, this toy can draw and sketch any image where you can use the photo function, put in a photo, and this fella will draw it out for you, and you can chat with it. Yeah, and as you chat with it, this software will interact with you. No second guesses that this market is for children, for kids, yeah, and for adults who have childish mentality, yeah. But anyway, ladies and gentlemen, this is the scenario that I'd like to throw to all of you. And we are going to be looking at the privacy implications here. So what I would like you to, all of you to do, think about it, okay? If you are a software developer, I would like you to think about the personal data that this scenario, this fictitious scenario that I've created with an IoT toy, what personal data does it create? So let me just take you back to the application just now. And I'd like to ask all of you, right? Tell me, in my fake scenario, ladies and gentlemen, what personal data would that mobile app combine with the IoT toy collect? And let's make sense out of this, okay? Now, folks, I know there are many of you. Can I ask that I would like to see unique personal data being collected. So before you click the submit button, look on the screen to see if there is a duplicate entry. If there's a duplicate entry, just make sure it's exactly the same. Yeah. So that the more people who chose the entry, the larger the words will get. Okay. So we got photo, age. So for those of you who are submitting your entries, try to follow whatever that is here so that whatever I have is unique. Okay. So if you think there's facial recognition, type face recognition. All right. So what we have, ladies and gentlemen, is a bunch of personal data that the mobile app is collecting. And again, I'm asking all of you to ensure that you put in identical to what is already here so that we have unique personal data, right? So there are 45 of you. I will continue once I hit 100. So ladies and gentlemen, you can see that face recognition stands out. Photos, the name of the child, we have pictures, we have the age, right? And I'm going to take you through and contextualize this for you, okay? So please enter whatever that you think is here and enter exactly the same so that the words will get bigger. Okay, I'm now at the 100 mark. So ladies and gentlemen, if we pause for a while, all of you can see all the different personal data that is being collected, right? So for those of you who can't see, you have video, you have birth dates, you got voice, full name, email address, photos, voice signature, and so forth. Okay, so you have no problem understanding. This is what we call a data inventory. You now know that in the course of processing the app, allowing the mobile app to work with the IoT device, yeah, these are all the personal data that you inevitably will be using. So I would like to take you through now what we call the information life cycle. And I want, again, especially the mobile app developers, in executing the function for the IoT toy to work with the mobile app. Let's imagine, ladies and gentlemen, we are selling this app with a fictional toy. First thing, I'm sure you would agree, you are going to be leveraging the sensors. The device itself, you'll be using the camera, the mic because of the speech to text, the movement sensors, yeah. Obviously, we will need to involve the smartphone and tablet. We are also using the mobile app and the browser, and we'll talk about trackers later. Obviously, you will need to have access to the Wi-Fi network, and that will lead you to the internet. So ladies and gentlemen, in the world of data protection, you would need to understand what data you collect, use, store, and disclose. Because in every data privacy, in every data protection law, there are rules that you will need to follow. Okay, so I would like you all to make sense of this out your own. But in our scenario, you would notice that just like many of you would do, you would register, you would obviously have a registration process where you have the member, he signs up as a member, right? So I'd like you all to think through this process. Obviously, the toy captures the data via the sensors in the IoT toy. Now, what happens is whatever the toy captures via the IoT sensors, the data has to be transferred to the mobile app. And inside the mobile app, obviously, as you have seen just now, the user will interact with the toy and the mobile app. So let's imagine data going to and from the IoT device and the mobile app. And as we execute the app, more personal data is processed. I'd like everyone to pause for a while and figure out what is the purpose of the application. What is the purpose of the toy and the functions? Yeah. For you to comply with the data protection law, you will always want to know what is the purpose of your processing, because that is something you need to know before you can think about how the data privacy law kicks in. So as we move on the life cycle, the data is stored in the mobile phone. Yes. And I'm sure a lot of you know that the data will then be sent to the cloud servers. But here's the thing, a lot of processing is done in the cloud. I think I saw one of you put in conversations, yeah, previous confidential conversations, because how the toy would work, obviously there is an interactive cloud platform that generates the response, and it keeps all the previous dialogues, because depending on your algorithm, some of you might have intelligent algorithm allowing the toy, yes, to interact with the user. But here's the thing, ladies and gentlemen, because we have the targeted ads inside, we can see that the data is being analyzed in the cloud to produce what? Usage statistics, and you will need all the detailed profiles for targeted advertising. And because you are part of an ad network, depending on your arrangements, I'm sure you folks, those mobile app developers in this session would know that you share data. Yeah, it could be a processor, a PIP. You could share with other apps. You could share in social media. And I also saw just now that many of you are using your mobile apps to collect or to process your e-commerce services. Okay, so I hope this is useful to all of you. I would like everyone to take a step back. Think about your own application. Yeah, I know that I've made it more complicated by connecting it to an IoT device, right? Which could be your watch. In my case, it's my imaginary toy. Yes? So as we take a look at the collection point, the use point, when all the processing we do, and that we store the data, and we store the data at the collection point, the use point, the disclosure point. And here, I like to just point out that the data is disclosed outside your company. And when we say transfer the data, we mean that the data is transferred to another country. Okay, so all of you having your own mobile app would have this same data flow. I want to now draw your attention on where the risks are at each stage of the life cycle. So the collection stage, the use stage or processing stage, the storage, and the disclosure stage. And I want to draw real life examples, and I want to challenge all of you. I want to challenge all of you in this summit to let me know where the risks are, or specifically, where do you think the risks are in your own mobile app? So I'm going to give you examples. As I said, let's go through each stage of the life cycle. And I want to draw real life cases of mobile apps that have gotten into trouble with data protection laws, both in the EU and in other countries. Okay, so a lot of you are familiar with TikTok. Yes. So this is the US government. And we know that they don't even have a data protection law at the federal level, right? But they do have laws at the state level. But the US government fined TikTok 5.7 million. And take a look for what? For collecting children's data. So for those of you who are offering games, for those of you who are offering tuition apps, let's see what happened here. So in this case, TikTok, what they did was they processed children's data, their names, the email, pictures, and locations from children under the age of 13. Yeah. So if you take a look, for those of you who are the legal folks here, you will know that there's a COPA and the Children's Online Protection Act. There have limits here, and they should get parental consent. And because they didn't do it, you can see the privacy issues. They collected sensitive personal information, and there was no parental consent for all of those below the age of 13. And as a result, ladies and gentlemen, what happened was FTC gave or imposed a fine of $5.7 million. Question for all of you: can this happen? Do you have applications which involves children's data? Because many of you will have your mobile apps not just in the Philippines, but in other countries that there are laws that you will need to take note of, right? And interestingly, if you look at the further areas, you will notice that in the EU, the Dutch DPA fined TikTok 750,000 euros for something we call transparency violations, which I think some of you by now would know that these same principles exist under the Philippines DPA, right? And here's the thing, they were fined for violating the privacy of young children. So because of one practice, ladies and gentlemen, you have the US going after the company, you have the Dutch authorities going after TikTok, all because of their privacy practices. So ladies and gentlemen, as we go through each slide, I would like you to think of the data that you process, and later we will link back to the requirements of the data protection law. Now, this is interesting. Yeah, this involves Google. Some of you may have read the case about Google. And a lot of us would have think that Google will have multiple lawyers. They will have many, many lawyers. But as we keep sharing with people in our courses, it is not just legal compliance. It's about operational compliance. You will need to understand how your apps actually work. Then only you are able to look at the compliance requirements. Yeah. So in this case, Google got into trouble because, I mean, for those of you who buy an Android device, the assumption here is when you register your mobile device, you would just say yes to the personalized target ads. Yes. So you just sign up, you do this, and they were hit with a 20 million fine, 20 million euros. There was the fine here, and they were hit with what is called lack of transparency, and they didn't provide adequate information on how actually they were doing it. Surprisingly, in the investigation, the regulators calculated that they needed 6 clicks of a button. I say this again, 6 clicks of a button. You've got to click 6 times just to get to the web page that allows you to switch off the targeted ads or at least personalize them. They got hit for lack of valid consent. So ladies and gentlemen, as you hear from the DPA or from the GDPR perspective, there are strict definitions of consent, and that is why the previous speaker were talking about, he was talking about having a consent mechanism in place. So can this happen to you, ladies and gentlemen? You make assumptions because of the money that can be made in behavioral advertising. Let's take a look at the next case. Now, again, I want to gently remind all of you, this is only collection risk. We are going to go through the entire life cycle. So for those of you who watch football, there's something called La Liga League. Yes, believe it or not, La Liga also got into trouble. They were fined 250K for alleged GDPR violations. And what did they get into trouble for? Let me explain. So what happened in simple summary, take a look on the left-hand side. The application tapped on the user's mobile app's microphone. So we're now talking about permissions. And while you get the app to watch your favorite football matches, they were trying to determine if the streams of soccer matches that you were watching were being pirated. And as you can see, because of that, they didn't tell you and they didn't allow the withdrawal of consent. So in this language, we are calling forced consent. And they were secretly, I say again, secretly tapping the microphone, right? As developers, you do know that the moment you request permissions for the microphone, you can switch it on and off, yeah? So this is what happened in the app, and La Liga was fined 250k euros for violating the GDPR, yeah? Let's move on to the next scenario, okay? This is the Chinese mobile apps, and this is something that everyone should be aware of. For the first time, the Chinese authorities, now you might have seen their cybersecurity law, and you may have seen that recently they introduced the PIPL, Personal Information Privacy, PIPL, Personal Information Protection Law. What happened was they actually went after mobile apps as long as the purpose of the app is processing excessive data, right, that is in proportion to the purpose. Guess what happened? They actually removed the apps from the App Store. For what? For violating user rights. And they were actually warned, these mobile apps developers were warned to change it, not to make their application so excessive, right? Because if you have all the permissions here, it's like giving your phone to the developers and they have full access to the information in there. So they got into trouble, excessive requests for permissions. And what did they do? Making mandatory for users to use the targeted push function and inadequate indication of users of app information on the application distribution platform. So we now see the importance of having your privacy notice telling the user how your apps are processing personal data, but it has to be proportionate to the functions, to the purpose of your application. So this is one, right? So as a result, these apps were removed, and we all know once the app is removed, it's hard to acquire a new customer, which brings us to the next point. Some of you may have read it. This is a well-publicized case. This company that provides ride-hailing, it's a ride-hailing mobile app similar to Grab, right? It was removed from the App Store, the China's WeChat and Alipay store. And as you can see, they not just removed one, they removed 25 mobile apps from all of the relevant web stores. And why was it removed? Let's take a look. Here is the point: illegal collection of personal data by Didi, which they were collecting data for its delivery services because they had access to the camera and the financial services. We can already see that the Chinese authorities were not happy. Now, if you understand the new Chinese data protection law, they are also very particular about their rights of their own citizens. Okay, so I'd like everyone to figure this out. Could you have an issue in this area that the permissions, the trackers that you do in your app, are they excessive to the function, the purpose of what the app is supposed to do? And this is very sad. This announcement was made just 2 days after Didi went public, affecting their share price. So I want everyone to pause. These are only collection risks, yeah? And based on the scenarios, the case study I shared with you, my question: do you have similar collection risks at your end? Because there is an active data protection law that is actually going after companies, not just in one, but in many countries. I would like you all to take a look now at, after you collect the data, it goes to the next stage. You will use the data, or you might do general processing in your mobile app. Yeah, you recall that in my scenario, the toy collects information, it passes on to the mobile app. The mobile app will do further processing. So I'd like to talk about this case in the Philippines, which I think a lot of you would know about this. Yes, and in this case, there was a pilot test of in Grab Philippines. And again, not everything we do has a bad intent. There was a good intent here because they wanted to ensure the safety of the driver. driver. Yeah. So what happens is that by turning on the video and the audio, it allows the employees in the Grab's office, their front seat, to see what's happening inside a vehicle. Okay, but this only happens when the driver prompts them if there's an emergency button. So that function will be made available, right? And this is a very quick summary. NPC suspended the pilot test, right? And this is something that we need to be very careful, not just in the Philippines law, but in the European law, that the rights of the company cannot, you have to do what's called the balancing test. The rights of the company cannot override the rights of the individual, or in this case, customers. Yeah. So while we have good intention here, we need to be aware, as we will see. Some of you may be aware that under the DPA, right, that all processing has to be adequate and non-excessive. Yeah. So whatever you do, you have to process it, and you will need to balance between the security side, as we see in this situation, and balancing it with the rights of the individual. Okay, so I hope this is one example. I want to, as a result, the action taken was a cease and desist. Okay, now what I want to do right now is I would like to play you a video of Singapore. This is the first case. Yeah, this is the first case of a company getting into trouble with the PDPA in Singapore. Okay, this is a smart weighing scale that is similar to the scenario that I shared with you. And I want to take this opportunity to play back this video, and you folks look at what actually happened. And the question here is, can this happen in your own company as well? All right, so let's watch this video.
Data privacy breaches in health devices. ACTXA, Singapore. How it unfolded. In November 2016, a complaint was made to the Personal Data Protection Commission of Singapore, the PDPC, alleging that Aksha Private Limited had transferred the complainant's personal data to its server without the complainant's knowledge or consent. Aksha markets healthcare and fitness-related Internet of Things (IoT) devices such as smart weighing scales. By means of sensors, the weighing scale collects the personal data of users, such as their weight, height, body mass index or BMI, total body water percentage, total body fat percentage, bone mass, and muscle mass. The complainant bought one of these smart weighing scales and also installed the Aksha app. To start using the Aksha app, a user had to enter his or her name, email address, password, gender, date of birth, height, weight, and country. He or she could also upload a profile picture if desired. Subsequently, the user could monitor his or her health data such as sleep pattern, heart rate, and weight trends, as well as the data collected by the weighing scale through the app. Not long after using the weighing scale, the user realized that his personal data was being transferred to and stored on the Aksha server, and that he had not been asked specifically to consent to that purpose. He lodged a complaint with the PDPC. The individual who complained felt violated and requested a refund from Aksha. Aksha acceded readily, providing a full refund. It also removed the user's personal data from its server. However, the complaint revealed that the personal data of 2,609 users of the app had been potentially compromised. The issue was exacerbated by the fact that the personal data involved included sensitive and health-related information. Findings. Aksha had relied on the privacy policy on its website to notify its customers of the purposes of the IoT device and the app, as well as to obtain the customer's consent for the collection, use, disclosure, and storage of data across all these platforms. Upon investigation, the regulator found that Aksha's privacy policy had made reference only to its website, but had not expressly addressed the collection, use, and disclosure of personal data via the weighing scale, the app, nor by other IoT devices. The regulator's decision. As a result, the Commissioner ruled that the organization had failed to obtain valid consent from the complainant and other Aksha app users, a breach of the consent obligation. In addition, the organization had failed to collect and use personal data only for purposes that a reasonable person would consider appropriate in the circumstances and for which the impact individual had been informed. This was a breach of the purpose limitation obligation. In deciding the penalty, the regulator took into account the prompt action of the organization in providing a full refund to the complainant and broadening its privacy policy to notify users about other platforms and devices. In addition, no other complaints had been received about ACTA. Given that sensitive and health-related personal data of 2,609 ACTA app users had potentially been compromised, ACTA was directed to pay a financial penalty of 6,000 Singapore dollars.
Okay, I hope you found this video useful. Now, some of you might be saying, but my weight, my BMI, that's not identifiable. But here's the problem, ladies and gentlemen. The moment it goes to the app, the weight, the BMI information can be associated and therefore it will be identifiable. You've also seen that many developers make the mistake that when they talk about their privacy policy, they don't reference what the mobile app does. In this case, it didn't even talk about what the IoT and the mobile app actually did. So I'd like all of you to figure this out, right? Could this be a problem? That you're just going through the privacy notice without really understanding what your mobile app is doing, right? And what aggravated matters here, this is health-related data. Okay, so I hope this gives everyone a good perspective on what is being done in the app. Some of you may have seen this religious app where this was reported quite widely, where the US military reportedly bought location data mined from a popular Muslim app. Again, the intentions are all good here. And this, as you can guess, right, was where the developer went to sell granular location data. Now, for those of you developers on this call, you know that when you tap the permissions, there is the specific permissions. There's one, I think, location by area, and the one is location, a specific location that's just a few meters apart. So what they did was they took that data, yeah, right? And because there's so many downloads, 98 million downloads, they work through a third-party aggregator. And all of you would know this, right? When you download your SDK and all that, it will belong to a third-party ad network. So that network was the one that was selling the data, right? And as you can see, because of that, it received lots of negative PR, yeah, because the data was sold to a data broker. And all this happened without the user knowledge, yeah? And you can see that what happened after that, yes, is that it's not just one regulator that is doing investigation. The Singapore PDPC was doing it, and many people were upset. They deleted the prayer app here. So I'll leave all of you to figure this out and what implications this has, right, in all of the good intentions that have been put in place. Yeah. Now, I want to talk about more sophisticated processing. So this involves a company called Foodino, and you can see the root word is food. We're talking about food apps, yeah. And this is what happened. This is where there's bias processing going on, yeah. So you can imagine that this is a food delivery company, and what it did was it adopted, because of the advanced processing that was done, right, what we call automated decision making, they were discriminating against their own employees, and the employees had no idea of how this will work. And the worst thing is the accuracy, and that the algorithmic results were not fair to them. Yeah. So what happened? So you can already guess. Yeah, they were fined 2.6 million euros because of the way they structured their algorithmic rating system, that the data was not accurate, and because it's not accurate, it was used to discriminate against the employees. Yeah. So you can imagine that for many of them, the riders were penalized, yeah, because of certain information. Their checks were being collected. Let's take a look. There was all of these activity was taken into account in the algorithmic processing, right? And you can imagine, you can then tell how active a rider is and all of that. And as you can see here, there are no suitable safeguards to ensure the accuracy and fairness of those results. Yeah, I'm aware that it's now 12 o'clock, so if you can allow me to finish at 12:15, is that okay, Jensen? Or I can start to close off. Yeah. Okay, so I'll just continue 12:15, and Jensen, you can advise me accordingly because I'm just conscious of time, right? So this company got fined 2.6 million euros. So now let me just go down to the storage part of the application, yeah? Okay, let's take a look. I'd like to ask all of you, how do you store those data, information that you might have in your membership system, in your app? So a lot of you may have read about this case that had to do with the Indonesian contact tracing app. Yeah, and what happened was 1.3 million had their 1.3 million people had their sensitive personal data and the associated COVID-19 results exposed in an open server. And believe it or not, there was zero data or security protocols. So what happened, as you can imagine, this was embarrassing to the Indonesian government, and we know that Indonesia is actually having a data protection law very soon, yeah, and this probably highlights the importance of having one. And you can imagine that there was no security measures being put in place. Yeah, by now all of you should know that under data protection laws, in Singapore, 80% of all enforcement cases is failure to secure data. Question for all of you is how you're doing it in terms of you processing data. Are there security measures being put in place? Yeah. I just want to close off here. You can see there's another case of what we call the Ever app. And this one got into trouble with the US where it used facial recognition. Yeah, the same technology that I'm using in my trick picture scenario. So this company is no longer in existence. Yeah, and this app was basically using patterns of the user, and when you do your facial recognition, it would then spam you with information after they provide the service. Okay, so they were selling your facial recognition imprint. So what happened? Let's take a look. You can see that they use facial recognition to the user's photographs without properly informing them what it was doing with their selfies when it was actually being sold. Okay, and as a result, action taken, they were ordered to delete the user data and remove all algorithms, because for all of you who know that when you do your AI, right, you got to the algorithms help to train the application, so all those algorithms would also have to be deleted. Okay, let's move on, yeah? And let me just close off. Okay, let's move on to the next slide. Okay, so these are all examples. Now, I do believe that this presentation will be made available to you, but if you do a quick check on the internet, no matter which industry your app is from, there have always been security issues, right? Leakage of data, unauthorized access to personal information, and so forth. Okay, so you can see that even how you store the data, whether you store it in the cloud or whichever area, or whichever network you are storing it, okay, down to the device itself, you need to take note of the potential issues in storing data. So now let me just come to the end of the information life cycle, where when you develop your mobile app, data will be disclosed, yeah, outside your company, and data could also be transferred outside to another country. So let's take a look at the cases here. This is something that I think many of you are really familiar. WhatsApp was fine. This is the most recent one, 267 million, although they are appealing to it. They are appealing. They were fined by the Irish, Irish authorities. Yeah. And what happened was, take a look. They were fined because WhatsApp, right, was sharing, yeah, information with Facebook. So the question for all of you, when you process your mobile apps, is the data being shared with a parent company or with some other company with good intent, of course, yeah? And what happened was no one knew about it. They didn't know that this was actually happening. I'm sure you all know that the recent issue or controversy with the WhatsApp privacy notice probably drew a lot of attention to it, that the data was being shared with Facebook. And here, ladies and gentlemen, the fine was 225 million euros. So we know they're going after the giants, right? But all these sets precedents of how mobile app developers can potentially get into trouble. Let's move on to the next one. I'd like all of you to read this quote that I'm sharing with you. If I'm a startup, I'm bootstrapping an app really quickly. And why? Because I have the good intention. I want to make my applications fast. I want to make something fast. So what do? I just bundle a bunch of SDKs. For the DPOs here, that's your software development kits in there. I compile the app, and what do I do next? I ship it off to the App Store, right? So this is something which you may find this familiar. And here's the thing, I may not be aware, literally, as a developer, what is in my own app, because what I have is an API, is a black box, I incorporate it into my application. So I want everyone to ponder this for a while before I end the morning session. Let's take a look at this case. This is a company called 4Shat. It's a file storage application. And what happened was they were caught serving invisible ads and making purchases without consent. Yeah. So you all know that the ad model is the more ads you serve, the more money you make. So here's what happened, right? This ad contains suspicious third-party code, and we can guess this is from the advertising network provider. Yeah, and what it did was it allowed the app to automate clicks and make fraudulent purchases. So this download, the codes here, was directly responsible for doing what? Generating the automated clicks without the user knowledge. Yeah, so how do you do it? You guys know we set a cookie, yeah, to determine if the advice has previously been used, and you can imagine what happened. So here they secretly displayed the invisible apps and subscribed to use the paid service, and you can imagine they rack up charges. Yeah, but what was amazing, ladies and gentlemen, this is what the spokesman said, that the company was unaware. I say again, they were unaware of the fraudulent and ad activity in its app until they were told. And what did they do? They confirmed that the company no longer worked with Elephant Data, which was the third-party advertising network they were working with. Can this happen to you, ladies and gentlemen? Right? So here are points where this is something which the regulators are very well aware. Apps are sharing user data. And because of GDPR, you can imagine the regulators are very particular, right? And you can see in this quote here, every time you open up an app, the advertising networks get your GPS location, device identifiers, and even the fact that you use a gay dating app. right? And for the developers on this call, you can imagine how you can get access to all of that via permissions and all that. This is something that is currently happening. So there was a report that was published, and there are many reports like that, right? So the report found that all the apps shared user data with multiple third parties. And what did they share? IP addresses, GPS location, personal attributes, and all of that. Yeah, because all those data are needed for the advertisement, for the targeted advertisements or advertisements to actually work. This is what happens here. All those information can be used to track and target users, as I said. So there's a lot of profiling going on. And from the behavior of the app, you can already guess, yeah? There are many sensitive attributes that can be identified, which of course can be sold. So what's happening behind the scenes? For the mobile developers, you know, this is something that you are aware, right? That part of the monetization model is to sell data. And I want to just point out to everyone that there has been research done, even though the ad network providers say that they don't process personal data, that is not necessarily true. So take a look at all of these stats. 7 out of 10 applications they connect to at least one tracker. 15% of apps connect to 5 or more trackers. So the rest of it you can read on your own, right? Because you can see that all of these are happening. The unique identifiers, ladies and gentlemen, are crucial for what? For online tracking services. Because as you can see, they connect different types of personal data for different apps to a single person. So there are all of these studies that they are going on here. So if you are a developer, you should take note and watch your software development kit. Do you really believe the advertising networks that actually tell you and promote to you, you can make money out of your app, right? Use our SDK and so forth, and we will do the rest. We will not process any personal data. I mean, you've seen messages like that, okay? So I'm going to end. Just give me 2 more slides, and then we will continue after lunch. Okay, let's take a look at, you can see that when the ad trackers work, yeah, users' online data, they're being shipped across national borders. Remember, we talked about transfer of data, and therefore they could go to companies that might have, or rather countries that might have questionable privacy laws. Yeah. So we take a look, more than 60% of all the connections to tracking sites, they are made to servers going out of the country. Yeah, and you can imagine what this means in terms of mass surveillance technology. And just to get everyone up to speed here, potentially, if there are data protection laws, you are covered by those laws. Yeah. So to close off, ladies and gentlemen, I thought I close up this section by sharing with you that they are also going after technologies or advertising networks. So in this case, a digital advertising startup, Vectory, they got into trouble because, as you can see, they didn't share with the user that they were using geolocation data collected from mobile apps distributed by third parties. Because the more data you have, the better targeting you can do. And they got into trouble because they didn't give consent. Yeah. So ladies and gentlemen, I hope you've enjoyed the session. So if I were to go back to our scenario here, in my imaginary scenario, in many of these cases, before I close off, ladies and gentlemen, I would like you to think about your own mobile apps. Because I showed you, ladies and gentlemen, that in every single one of these stages, an organization has got into trouble, right? So with that, I'm going to take the opportunity to stop here, and I'm going to continue after lunch, where we will link this back to the Data Privacy Act, and we'll be talking about data privacy or data protection by design. So I hope you enjoyed this morning session. And Jensen, I will hand back to you at this point. Yes?
Thank you very much, Mr. Kevin Sheberson of the Straits Interactive. Thank you also to our dear participants for attending the morning session of the DPO 24 Technology Sector Summit. Please do come back here at exactly 1 p.m. for the PM session where we discuss further the mobile app privacy with Straits Interactive and discuss with experts the best practices, current trends, and related topics. This is DPO 24 Technology Summit, hosted by the National Privacy Commission. Thank you and have a great lunch.
Bukod sa social media, gaming, videos, importante rin ito para sa ating pag-aaral. Lalo na ngayon that we're living in the new normal. Maraming magandang dulot ang internet, pero kaakibat nito ay mga posibleng panganib. Through DTP's e-modules, matututunan natin ang wasto at responsableng paggamit ng internet, cyber safety, online behavior at iba pang mga kaalaman para masiguro that you're safe and protected in the digital world. Ganito ba kayo? All day and all night you're glued to your mobile phone, laptop, or tablet device kaka-internet? Kung masyado na kayong babad sa internet, abay hinay-hinay lang because there is such thing as internet addiction. Mahilig talaga tayong mga Filipino sa internet, lalong-lalo na sa social media. At ang mga kabataang Pinoy ang nangunguna rito. So it's no surprise na ang Pilipinas ay hinirang na isa sa world's heaviest user ng internet. Kaya't hindi katakatakang mauwi ang ilan sa atin sa internet addiction. Sobra-sobra na ba ang paggamit nyo ng internet? Yung tipong nag-i-interfere na siya sa inyong buhay at ginagawa nyo na siyang priority over your family, friends, work, at studies. Nako, kailangan nyo na mag-slow down dahil baka internet addiction na yan. Dahil sa excessive na paggamit ng internet, naaapektuhan na rin ang inyong relationships. Napapabayaan ang inyong pag-aaral o pagtatrabaho, pati na rin ang sariling kapakanan. Guys! Hello! Malaki ang nagiging epekto nito sa inyong mental at emotional well-being at sa pag-aalaga ng inyong sarili. Dear, hindi maganda yan. Piracy yan, illegal downloading and streaming. Naku, mapanganib yan. Sayang naman, libre pa naman. Hindi mo na kailangan mag-subscribe. Wait! Hindi ka ba aware sa identity theft? Free nga, pero maaaring may kasamang viruses at malware na pwedeng mag-access ng personal information mo. Gagamitin ito ng mga online thieves to pretend to be you sa internet. Bukod pa dyan, pwedeng ma-access ang camera mo nang hindi mo namamalayan. So no! Ang tagal ko pa namang hinintay to. Marami sa atin ang bumababad sa social media o downloading and streaming sites. Dahil mas madali at mas mabilis nating na-access ang mga content na gusto natin. But not everything on the internet is safe base sa ibinahagi namin at di lahat ay legal. Online piracy is an illegal and criminal act. You do harm to the people working in the industries that you pirate from. Tulad na lang ng movie industry. Ang mga pelikula ay hindi kumikita kapag marami ang nanonood o nagda-download nito from illegitimate sources. Dahil dito, nawawalan ng budget para gumawa pa ng mga pelikula. Kaya nawawalan din ng trabaho ang mga tao sa industriya. Isipin na lang natin kung ilang tao kasama na ang pamilya nila ang naaapektuhan nito. Dagdag pa riyan ang negative effects ng piracy sa ekonomiya. Ha? Ano namang kinalaman ng piracy sa economy? Dahil ang mga producers ay nagbabayad din ng tax sa gobyerno, lumiliit ito kapag nababawasan ng sales ng kanilang mga pelikula. Masama pala talaga ang effects ng online piracy. Maliban pala sa akin, marami pang buhay ang pwedeng mapahamak. Isang malaking check ka dyan, kaya make sure to always #PlayItRight. Help stop online piracy. Find out more by visiting #PlayItRight website. Hindi porket libre ang mga nakikita natin online ay tamang i-download o i-stream ang mga ito. Piracy is illegal at may mga batas na nagpipinalize sa mga gumagawa nito. Maraming legitimate at legal sources na pwedeng pagkuhanan ng movies, music, software, at kung ano-ano pa. Ugaliing mag-subscribe sa mga ito para sa safe at secure na content. Learn more about how to #PlayItRight by visiting globe.com.ph/play-it-right. Hanggang sa muli, mas marami pa tayong matututunan sa mga susunod na DTP e-modules. Let's create a safer online environment together. Bye! Malaking bahagi na ng ating buhay ang internet. Bukod sa social media, gaming, videos, importante rin ito para sa ating pag-aaral. Lalo na ngayon that we're living in the new normal. Maraming magandang dulot ang internet, pero kaakibat nito ay mga posibleng panganib. Through DTP's e-modules, matututunan natin ang wasto at responsableng paggamit ng internet, cyber safety, online behavior at iba pang mga kaalaman para masiguro that you're safe and protected in the digital world. Ito! Full movie! Ad-free pa! Yes! Dear, hindi maganda yan. Piracy yan, illegal downloading and streaming. Naku, mapanganib yan. Sayang naman, libre pa naman. Hindi mo na kailangan mag-subscribe. Wait! Hindi ka ba aware sa identity theft? Free nga, pero maaaring may kasamang viruses at malware na pwedeng mag-access ng personal information mo. Gagamitin ito ng mga online thieves to pretend to be you sa internet. Bukod pa dyan, pwedeng ma-access ang camera mo nang hindi mo namamalayan. So no! Ang tagal ko pa namang hinintay to. Marami sa atin ang bumababad sa social media o downloading and streaming sites. Dahil mas madali at mas mabilis nating na-access ang mga content na gusto natin. But not everything on the internet is safe base sa ibinahagi namin at di lahat ay legal. Online piracy is an illegal and criminal act. You do harm to the people working in the industries that you pirate from. Tulad na lang ng movie industry. mga pelikula ay hindi kumikita kapag marami ang nanonood o nagda-download nito from illegitimate sources. Dahil dito, nawawalan ng budget para gumawa pa ng mga pelikula. Kaya nawawalan din ng trabaho ang mga tao sa industriya. Isipin na lang natin kung ilang tao, kasama na ang pamilya nila, ang naaapektuhan nito. Dagdag pa riyan ang negative effects ng piracy sa ekonomiya. Ha? Ano namang kinalaman ng piracy sa economy? Dahil ang mga producers ay nagbabayad din ng tax sa gobyerno, lumiliit ito kapag nababawasan ng sales ng kanilang mga pelikula. Masama pala talaga ang effects ng online piracy. Maliban pala sa akin, marami pang buhay ang pwedeng mapahamak. Isang malaking check ka dyan, kaya make sure to always #PlayItRight. Help Yes! Naalala ko na! Naku! 1carat_48. Ayan, there you go. Tagal ko nang di nabubuksan. Buti na lang, mahirap yung password ko, kaya intact pa rin lahat ng messages ko. Minsan ka rin bang nakatanggap ng notice tungkol sa suspicious access sa account mo? Naku, posibleng hackers na yan na sinusubukang hulaan yung password mo. Bakit nga ba importanteng magkaroon ng strong password? Dahil ito ang first line of defense laban sa unauthorized access sa accounts at gadgets natin. Protection din natin ito against malicious cyber threats na ginagamit to commit financial fraud and identity theft. Dahil nakabase ang password strength sa length at complexity.